So my name's Shane Farrell. I'm the Small Practice Support Administrator here at Support Services in the Law Society. First up, the good news about setting up in practice is it's a simple process, relatively simple. All you need is the practicing cert, PI insurance, and you need to notify the Law Society. However, setting up a successful practice is more complicated. And that's why we sorted this morning out and we got our group of speakers. So first up, we're going to have Keith O'Malley, Support Services of the Law Society of Ireland. He's going to be talking about progressing your idea into a reality. So from concept the whole way through. Then we're going to have Simon. Simon is a Legal Services Regulation Executive, and he's going to be talking about Regulation Department requirements. Eamon next. Eamon is our Advertising Regulation Executive. He's in the Law Society Regulations Department, and he's going to be speaking to you about solicitors' advertising requirements. Then we have Terry Dunn. Terry Dunn's a Professional Indemnity Manager at First Ireland. It's going to be a general talk in regards to professional indemnity insurance. We're going to have a quick break then, and after the break, there's tea and coffee outside with some snacks. After the break at 11:30, we're going to have David Rowe. David Rowe is the Director and Founder of Outsource Finance. Again, setting up in practice the accountancy management side of things. Sabina Horgan of Tread Legal. She will be discussing case management. Shane Brannigan, Sales Manager and Expediate, about your IT systems, cyber security, that side of things. Then we have Anne O'Connell. Anne O'Connell is a principal of Anne O'Connell Solicitors, a very successful small practice, so she will be talking to you in regards to pitfalls, complications that she encountered herself. And we had Yvonne McCormick coming in from Hayden Accountants. Unfortunately, she can't make it, but we have Damien McCarthy. He is Head of Legal Services in there, and he'll be talking about your auditing accounting requirement.
Good morning. My name is Keith O'Malley. I'm here this morning to talk about progressing an idea, an aspiration that somebody has about setting up a business into a reality. And I'm going to talk about three things. I'm going to talk about the normal matters that need to be organised if you want to set up in practice, then factors that you should consider, think about, and finally preparatory work that you should do. So going straight in and talking about matters to be organised, a lot of these things are kind of obvious, but I think it needs to be said, and I think these matters impact on what I next want to talk about, which are factors that you should consider, you should think about. So if somebody is setting up in practice, you're going to need a premises. Some people decide to set up and operate out of their house, and that can work if you are providing a certain kind of niche service. Maybe you're a commercial lawyer and your business is with Google and Facebook and people like that, and they simply want you to you don't have any you're not sitting down with clients, you're not bringing clients into your home. But for most legal practices, it is best that you're someplace which is removed from your home, and how good that premises is, how big it is or whatever, is very closely linked to the impression you want to leave with clients and prospective clients. And then facilities are important. If you're going to have an administrator, receptionist, or somebody help you with administration, that person needs to be accommodated with furniture and obviously computer and telephone system, all that kind of stuff. So a person who becomes self-employed very quickly, you end up almost responsible for two homes. You've got the place you live, and then you've got this workplace that you've got to be able to accommodate yourself, clients coming in, a reception area sometimes, and also some place for staff to work. So you become quite good at facilities management. IT system is terribly important, and website. It is said about for solicitors and websites that a website won't bring you business, but it will, not having a good website will lose you business. Think about, if you were going to look at a deal with an insurance broker or something like that, the first thing most of us tend to do is you Google it, a business, and you look at it. So if you don't have a website now, it doesn't have to be the greatest ever website, but it needs to reassure a person who looks at it, and so you need to do that. It's something you need to organise. Regulatory compliance is important. Obviously, as Shane just said, there isn't an awful lot of compliance in setting up, but quite quickly things mount up, and there are things, particularly in the whole area of accounts, that you've got to attend to. And that's going to be covered as the morning progresses. Marketing. I have an awful lot of solicitors we talk about, and they poo-poo marketing. They say, it's what's that word? It's unbecoming. Marketing is unbecoming. I think that's an unfortunate and an unwise approach to take. I think if you're setting up a legal practice, it is important that you think in terms of setting up a business. It's the same as any other business, and if you think that you're setting up something which is quite different, and that you're a legal professional and it's not like another business, that's a mistake. And if you think about marketing, what marketing is, all it is the discipline that says, how can I make sure what I do is relevant to the marketplace? So it's about understanding the marketplace and what customers want, and then responding to that as effectively as you can. And then a slight add-on that it can also be publicity and promotion. But the important thing is, about marketing, it's not the publicity and the promotion. It's about interfacing with the market in an effective way. So it's about knowing what customers need and figuring out how to most effectively meet those needs. So marketing, I would say, is really, really important. And if you're thinking in terms of setting up a business, it's something that you should attend to. Financial control. A lot of solicitors are not great on numbers and all of that, but again, if you're running a legal practice, you're running a business, and you're going to have to become aware of a whole load of issues about VAT, how much VAT you need to charge, the way that VAT complicates things like cash flow, because you may charge somebody, send an invoice out to somebody, and depending on the arrangement you have with the inland with Collector General, you can find yourself actually responsible for VAT before you get the invoice paid. So you just need to be careful, and there's a whole load of there's no way really you can run a business unless you get you get skilled in the whole area of finance and financial control, that you can read a profit and loss, you can read a balance sheet, and you know what you're doing. You can get help, and it tends to come at two levels. You are very likely to have somebody who's going to do your books, or certainly set up your books for you, and then you have, at a higher level, you have an accountant who comes in really and checks that the books are accurate and right. But if you're running the business, you've got to be on top of all of that stuff. Yes, the accountant is going to know things that you're not going to know, and they will guide you in all of that. But very quickly, you've got to get on top of things, and you've got to make sure that the accountant isn't coming in at the end of the year to a whole load of unpleasant surprises. So it's really important to be on top of financial control. Factors to consider. I'm going to talk you through 4 factors. First is, will self-employment suit you? What resources can you access? What are your options? And what will ensure success? I'm going to start with, will self-employment suit you? it's really important to understand that when you set up a business, when you become self-employed, suddenly you're responsible for everything. If somebody is sitting in a chair and the chair falls over, quite apart from the liability you might have, they get injured, that chair needs to be fixed. So you find yourself getting very good at lots of things, or most certainly, if you're not doing them yourself, you've got a network of support. So you'll have a carpenter, you'll have an electrician, you'll have an accountant, you'll have a bookkeeper, you'll have a marketing person, you'll have a website person. So you've got all these to manage all these relationships. You are responsible for everything around you, and if something breaks, you've got to fix it. It's as simple as that. And it's something that one of your staff members has breaks or is using, you've got to fix it. So it really is the case. And the next thing is, of course, at the moment, with unlimited liability for solicitors, if your business goes bust, there's every possibility that you can lose everything. You can lose your house if you have it. You can end up, with big debts that you might have to go through a bankruptcy process or whatever. It can, failing in business and in a legal practice can, have huge implications on your own personal finances and your own personal life. So it is something that you need to be careful with. So everybody, before going into business, really needs to get some sense of their risk tolerance. Are you happy with a situation where you send out invoices and you're not quite sure how quickly the money is going to come in? Is it going to come in a week? Is it going to come in 2-3 weeks? How do you feel about phoning people and asking them for money? All of those kind of things. People who do well in self-employment tend to be quite egotistical. Being good or successful in business often comes down to somebody who, for whatever reason, tends to be, the business almost becomes part of them, and they become, part of the business. It represents them, and it's a source of huge pride and that, and so that's the kind of person that business suits. And Bono said it years ago that it takes a certain kind of inadequacy in a person to want to stand up in front of 50,000 people and sing every night, Well, it's the same in business. In a lot of ways, there's an inadequacy almost required to be successful or for a lot of people in business. And it's to do with this thing of, wanting to go out and prove to the world that, you're important and you're relevant. And they are the kind of people who do well in business, and other more passive people can set up successful businesses, but by and large the people who, there's a correlation between, I guess, aggressive egotistical attitude and a person who does well in business. And you need to have all-round business ability. The person who's going to do well in business is somebody who's comfortable enough, yes, handling legal matters, but also handling bookkeeping and accounting matters, also handling marketing, maybe learning WordPress and doing their own website. They're the kind of people who tend to do best, because the least times you need to call in somebody else to do something for you, quite simply the best. So that's the kind of thing you need to think about before going into business. If you do feel that self-employment is for you, then you're going to need to access a lot of resources. The first is funding. It is expensive to set up a practice. Even if you're setting it up from home and you're going to keep your cost to an absolute minimum, it still is expensive, and it always works out to be more expensive than you expect. The general advice given with regard to setting up any business is that you do financial projections. You lay out, you estimate how sales are likely to come in, when that money is going to come in, and how you're going to the kind of expenses you're going to have. And the advice is, whatever you think you're going to do, when you've calculated it all up, double your outgoings, double what you think you're going to spend, and have what you're going to, what you expect to get in, and then you're, down for you're down closer to real figures for your first year. It is tough setting up a business. It is a lot tougher than you, expect. Most people go in. If you survive the first year, it gets easier the second year, and suddenly, or by year 3 you start to think, I'm going to survive, I'm going to make it. But that first year is very, very tough. And so if you go in without enough money, it's a mistake, and we're going to talk about that in a later slide, about how you figure out how much money you need. Have you got a network of support? If you're going to need things like work on marketing, work on a website, work on premises, do you have people who can help you? And kind of looking out at projecting out the kind of work that you're going to have to do to set up a business. Do you believe that you can access people that can help you and facilitate you? Have you got a following? What we're talking about here are clients. Are there clients that are likely to come with you? It does help, obviously, if you're setting up, if wherever you've been working, you've been doing 150,000 last year, that if you set up on your own, that 1/3 of that 50,000 is definitely going to come. It helps. And do you have a particular expertise? I've seen an awful lot of people set up practices, and they have, specialised in one area. I saw one person who was setting up in Dublin, but then personal reasons had to move about 70, 80 miles outside. And she decided to focus her practice on one small area of business, and that was multi-unit development, so apartment blocks. And she does that from 70 miles outside Dublin because, she didn't believe there was the work within the town that she was going to live. So she had to find some kind of work that would she could access remotely and do remotely. I met somebody else recently who has set up a business advising and doing contracts and that for people in the whole area of intellectual property. So she works with artists and all sorts of creative people. And she found herself in that business because she found herself working in that kind of space, and she started, she did, to really, fill up her time a bit, she started doing some lessons within the enterprise centre she was in, and a lot of these creative people came to her, and out of that her business has grown, and she's found herself within that particular niche. There's somebody out in West Dublin, and their business is just debt collection for one particular industry sector, and that's all. Again, it's a woman. That's all she does. So, if you have a particular expertise, quite often, that can help you if you're setting up, and we'll look at a reason why in a moment. So, what are your options? We're talking this morning here about setting up a practice, but of course things are never quite that simple. You can set up a practice as a sole practitioner. You also have the option of setting up a partnership. There's different kinds of challenges with regard to setting up a partnership. You're working with somebody else, and there's strengths and weaknesses within that. You also have the option of buying an existing firm, and I would say to anybody at the moment, particularly maybe outside of Dublin, if you're thinking of setting up a practice, look at the option of buying an existing firm. Whatever you pay for it is probably largely going to be deferred. You won't have to pay for goodwill and for work work in progress, by and large, up front at the moment. Legal practices don't. There isn't much value in legal practices. There haven't been for the last 10 years. Accountancy firms, you pay 1 year's turnover. So, if you're buying a practice that has a turnover 200,000, you'll pay 200,000 for it. And that used to be the case with legal firms, but it isn't the case anymore. And there's very, very good value to be got in buying an existing firm. So it is something that a person should look at, because what the difference between buying an existing firm and setting up is that immediate cash flow. That if you buy a firm, depending on what you buy, whether you buy debtors and whether you buy their work in progress, there's the possibility that the day you go in, there is money coming in, straight away. So it is something you look at. And the other option for becoming self-employed is, of course, to join an existing partnership. And the booklets that we produce for this have a leaflet both about buying an existing firm and joining an existing partnership with information on that. What will ensure success? It is a fact that the legal market, the market for legal services, has changed dramatically in the last few years. There was a time that if you set up Mullingar, you were going to get all the business from around Mullingar. Now people go on the internet and they buy services. They deal with legal firms, right around, in a completely different part of the country altogether. So buyers have become much, much more sophisticated, and as a result of that, work has tended to divide it two ways. It's either price driven, for example, work like conveyancing, or they quite simply want the best. So it's reputation based. And if you're setting up a firm, increasingly that's the kind of competitive market you're going to have to cope within. Clients are much, much more demanding. If you think back 50, 100 years ago, solicitors existed in a world where a large proportion of the population was illiterate. That isn't the case anymore. People have, a good understanding of law, and they're becoming ever more and more demanding in terms of what they're looking for is value. And you've got to figure out how you can do that, how you can operate your business in a way that your clients are perceive themselves as getting value from you. Which leads on to this issue of specialization. Increasingly, legal firms, more and more firms, are moving away from that absolute general practice model where, whatever comes in the door, we'll deal with it. It's very difficult. What is the most lucrative kind of work a solicitor can do? I could go around the room and ask. It is a trick question, because it's not litigation and it's not conveyancing, it's not probate. What it is the same work that you did the day before. So if somebody comes into you and says, I need this complicated probate matter dealt with, and you do deal with that, and the following day somebody else comes in with exactly the same problem, and somebody comes in the following day with the same problem, then you start to make money. So doing bespoke work, where every time somebody comes in, you're having to learn, familiarize yourself with latest issues and all that, it's very difficult to make money that way. So specialization, it tends to allow a solicitor to operate much, much more effectively. And of course, it's also much better for marketing yourself. If you get a name for being particularly good at complicated probate matters, then work will come to you. And that's the kind of work that you can is reputation based. So you're not being asked to do it for nothing or next to nothing. It is not price driven. Can you exploit technology? It's, I think, really interesting to see people now, businesses, exploit social media in all sorts of ways. One thing I find amazing is no solicitor, as I understand it yet, has moved into that simple area of YouTube. You can't go on to YouTube and get little updates on legal matters. Nobody has done that yet. So they're the kind of things that can be looked at by somebody setting up a practice. preparatory work to do. It's really important that you produce a business plan. If you go to get any kind of support, anything like bank funding or anything else like that, you're going to be asked for a business plan. And a business plan simply lays out in a story what you expect to do. And it tends to end with some financial accounts at the end, projected financial accounts. And it's really, really important to do it, because you'll find it difficult to for people to take you seriously unless you've done a business plan. But far, far more importantly is what it does is it makes you think about what you're doing. And if somebody says to you, oh, I'm thinking of setting up a business, and you say that's really interesting, what do you expect to do in turnover in the first year? That's quite an acid test, isn't it? They either know what they're talking about or they don't, and that comes down so often to their ability to project their sales and estimate what kind of income they'll do. Income will come in from those sales, and that's what you get by doing a business plan. And there's a whole load of complicated things in setting up a business, as I said earlier, things like VAT, that only by doing a business plan do you understand they weave, one way or another. You pay VAT on your purchases, but if you're registered for VAT, you can get that back. But there's all timing issues. So they're the kind of things you do. So what I would propose to you is you do a business plan, and you do it early in the process. You start and you get your first draft, your first attempt at a business plan. And then as you get to understand the business and you make more concrete plans, you keep updating and upgrading your business plan. And so then anytime somebody wants to know about the business, you can give them a 5 or 6 page report on your business. Sorry, one last slide here, I think. So what you need in a business plan is an introduction, an operational plan, a marketing plan, sales forecast, and financial projections. Operational plan will tend to have staff, deal with, if you are going to have staff, what kind of facilities you're going to have. It'll have a financial plan or a funding plan, where you're saying, well, I've got 50,000 coming in, or 20,000, or whatever it is, and I expect that to use that as working capital and to get the business off the ground. You list any resources you have, and you give some personal information, so a short CV to say where you've worked and that kind of thing. In terms of a marketing plan, it's that 5 P's again. You identify where you're going to operate. You identify the people that you hope to sell to, the product that you tend to offer, price and promotion. Forecast. Nobody else except a promoter can forecast sales. Financial projections are something you should go to an accountant to get help with, but you're going to have to do all the groundwork. You're going to have to forecast what you think you're going to do in month 1, month 2, month 3, and you do that by obviously multiplying your charge rate by the amount of time you expect to work. And so the first thing is it's important to you forecast your sales, and out of that then your accountant will help you project what kind of income you're going to come, and out of that then is cash flow. And the accountant will do the cash flow for you, but you're going to be giving them all the figures really. There are complicating matters, as I said, like VAT and lots of others, and doing the financial forecast of the financial projection of a business plan is a collaborative effort. You're going to do it in conjunction or collaboratively with an accountant, but you're going to have to do all the groundwork. They cannot project your sales or anything else like that. And what you then have is a very valuable benchmark, because 3 or 4 months into the business, you look at what sales you've done and you compare them to what you expect to do as laid out in your business plan, and you see how you're getting on. That's my presentation. I'm going to pass you on now to Simon Traynor.
A very good morning. My name's Simon Traynor. I'm a practice regulation executive in the Society, and one of my roles is dealing with commencement in practice. And I just want to propose to take you through a brief overview of what we require in the regulation department when you're commencing in practice. So, in a nutshell, there's 4 requirements. You need a practicing certificate, you need a commencement in practice form, you need professional indemnity insurance, and if you choose to use it, headed note paper. So, looking at each one of these in turn, practicing certificate, Section 56 of the Solicitors Amendment Act 1994, you cannot practice without a practicing cert. It is a criminal offence and professional misconduct for a solicitor to practice or provide legal services of any kind without a practicing certificate. Any solicitors practicing within the practice must have a practicing cert, and they cannot be called legal executives, paralegals, or anything on that nature. And if you haven't held a practicing cert for 12 months, you may be asked to do a Section 61 application. Now, a Section 61 application requires you to detail how you've kept up with legal knowledge in the time that you have not held practicing certificate. So you send that in conjunction with your practicing certificate form to the Society. And if you do have to make a Section 61 application, it is advised to make it longer in advance than you would for a normal practicing certificate. So for a normal practicing certificate application, we would recommend that you make it at least 2 weeks in advance of when your commencement date is. So if you're making a Section 61 application, make it that bit earlier. Just to say, the practicing cert season starts from 1st of January to 31st of December in a year. If you want a practicing certificate to be dated the 1st of January, you must make an application on or before the 1st of February in that year. And a completed application requires both the completed application form with full fees paid. Now, so next we have the commencement of practice form, which is a very basic form. It just requires, the society requires the information about the practice, so who the principals are, who the assistant solicitors are, the premises, if there's any branch offices, telephone numbers, fax numbers, website, that kind of information. You're also required to give professional indemnity insurance confirmation. I'll look at that a little later as well. Financial information, so that will be, you're going to look at the financial year end that you're going to take for your solicitor's accounts regulations. And we also require a nominated solicitor in the event of death or incapacitation. Now, so the Solicitors Accounts Regulations are Solicitors Accounts Regulations 2014. The name of the reporting accountant must be noted on the commencement of practice form. Now, the Society would recommend that you get an accountant who has dealt with solicitors' accounts before. If you don't have an accountant who has done this, you are required to send in the accountant's professional qualifications, their professional indemnity insurance. So the reporting accountant's report, every year you must file your reporting accountant's report, and that must be 6 months after your financial year end. I would estimate approximately 50% of firms choose the 31st of December as their financial year end. Therefore, their accounts must be in with the Society by the 30th of June the following year. The Society has no discretion in this regard. It's a statutory requirement. It must be filed with the Society within that 6-month deadline. And it is recommended that you engage your accountant with plenty of time before your accounts are due. If you hold no client monies, you may file a statutory declaration with the Society to that effect, and that statutory declaration would also state that if you do hold client monies, you will inform the Society immediately. Professional indemnity insurance, absolute must. You cannot provide legal services without professional indemnity insurance. The minimum cover is 1.5 million for each and every claim, and it's done on a firm basis and not on a solicitor basis. However, if you do have changes in your practice during the year, it is recommended that you inform your insurers of any solicitors that have started or any solicitors that have left. The common proposal form, and this year's new common proposal form I think should be up on the Society's website next week, and it is in a fill-in PDF format, and it's recommended that you use that rather than do a handwritten format. It's recommended that you fill this in and get several quotes from different brokers and shop around, see what the best price that you can get on the market. The Society requires confirmation of cover in two forms. So when you make your commencement of practice form, you get a paper confirmation from your broker, and they would stamp that and send it into the Society with the commencement of practice form. And then when the practice has commenced and you're issued with a firm number, you're required to get your broker to log in to the Law Society's PII portal. All the brokers are familiar with this system, and they must confirm cover within 3 working days, and that is a requirement as well. And I put a note here on succeeding practices in the event, as Keith was saying, you were to buy a practice or take over a practice and it was going to be a succeeding practice. The Society does not define what is a succeeding practice, and this is something you should engage with in your insurer. And these are just some things that would be indicative of what could evaluate a succeeding practice. So that's not a substantive list, it's just a few ideas of what could be considered to be a succeeding practice. Professional names. So the name of a practice must comply with the Solicitor's Professional Practice Conduct and Discipline Regulations 1996, and the practice should consist of the name of the principal or principals of the practice or former principals. Now, if you are going to deviate from that, you will need to make an application to the Regulation of Practice Committee. That is done via paper submission, so you can make a submission to the Society. If you want to call your practice maybe Acorn Legal, you would actually have to make your submission to the Society why you want to make this, why you want to call your practice something like that. There is a standing approval for names such as legal, so if you want O'Brien Legal or O'Brien Law, there's no need to make an application on that, but any deviation outside of those will require an application made to the Regulation of Practice Committee. And professional note paper, should you choose to use professional note paper, it comes under the same regulations. The name of principal and partners must be listed on the head of note paper, even if that practice is carried on under their true surnames. You must differentiate between who is a principal and who is an assistant solicitor, and if there are any other persons listed on the note paper, they must be unambiguously stated. And I thought I'd just leave some information here. Like, there's a huge amount of resources available on the Law Society's website. Ironically, this weekend the web team are actually working on the website, so it's not available until after Sunday. But these are some of the useful links that you can contact if you have any queries about those. But I would say, have a look on the Law Society's website. There's a huge amount of information there. But please feel free to contact us concerning any of these matters at any time. And I think that's everything for me. I think I'll hand you over to Eamon, who's going to give you some information concerning solicitors' advertising.
Yeah, that's fine. Hello. So I'm Eamon McGuire, and I'm the Society's Advertising Regulations Executive. The slide that's up now is actually, I think, the slide that you've been provided with, and I had put together an abridged version of that. So I'll just quickly kind of rattle through the points that I wanted to make, which were really just in terms of the overview of what this brief presentation will involve is I wanted to set out to you what the purpose of the advertising regulations were, The manner in which the Society enforces the advertising regulations. The advertising regulations and their application to all advertising platforms. It's a common, I think, misconception that the advertising regulations, having been drafted in 2002, that they don't apply to all forms of social media, and that's incorrect. So I just wanted to clarify that. I then wanted to go through just some common areas of concern, and then just talk about the Society's vetting service, and then the future for the advertising regulations, because obviously the LSRA Act has passed, and although the specific section that relates to advertising regulations hasn't been enacted, I'll just talk about just the kind of current climate and the future for them. Really, yes, the purpose of the advertising regulations, although they're listed there more fully, it's really just three things: to preserve the profession of the reputation, to preserve the reputation of the profession, to act as a public protection measure, and then to ensure that a level playing field is maintained for all throughout the profession. In terms of how the advertising regulations are then enforced by the Society, it really takes a three-pronged approach. There's the proactive enforcement, which would be my function specifically, and what I would do would be to review all local and national print, radio, media, newspapers, articles. The Society engages media monitoring services to help me in that, and then I would conduct a county-by-county review periodically of solicitor firms' websites and their social media platforms. So from that then, what generally would happen is, if I was to identify a specific breach, for instance, I find that it's much easier to engage in a conciliatory basis with the solicitor in question directly through correspondence. And because I don't hold myself out as, say, an arbiter of taste, if there is an advertising or a specific kind of if there's content that may be questionable, I would put it to the solicitor and ask them, do you think this is in bad taste or may call the profession into disrepute? And generally 8 times out of 10, the solicitor would say, yes, absolutely, no problem, they take it down. But where that doesn't happen, I would say, right, okay, that's fine. I'm not making a decision one way or the other because I'm not empowered to. So I refer the matter on to, there is a advertising regulations division of the Regulation of Practice Committee, and the panel itself of committee members is made up of 3 solicitor members and 2 lay members, and so they that would then adjudicate on whether it is or isn't in breach of the regulations. There's also then a vetting service that the Society provides, and so if a solicitor is considering publishing content, they can put it to me for review and approval in advance of publication, and I can then give feedback or suggest changes, and we can agree together on what is considered to be, appropriate. And then finally, there's just the education element of the advertising regulations. I suppose, although the regs, as I say, were drafted in 2002, it wasn't until 2014 really that the Society took a proactive approach towards the enforcement of them. Previously, the responsibility for enforcement fell to the Complaints and Client Relations Committee, and so that meant that the regulations were only really enforced whenever a complaint had been made, whereas now, since 2014, it's more proactively enforced, and that includes then the publishing of guidelines on the regulations, which are available on the Law Society website. There's a seminar that's available on it, which is this actual full presentation is provided as part of a CPD cluster event, and then there's regular practice notes and articles that are published again in the Gazette or on the Law Society website or in the e-zine. Really, in terms of in terms of social media, I suppose, as I say, the regs predated the advent of all of the various ways in which online advertising manifests itself. But just to be clear, and I think you have a copy of the advertising regulations with you or in your pack, the definition of advertisement means any communication, whether oral or in written or other visual form, and whether produced by electronic or other means, which is intended to publicise or otherwise promote a solicitor in relation to the solicitor's practice. So that does encompass all social media, and as such the same care needs to be taken to comply with the regulations across all online platforms. In terms of, I suppose, specific areas of prohibitions, and these will just be the kind of common areas of concern that I wanted to discuss with you. Personal injury advertising is probably the area that is, I suppose, most heavily regulated, and although there is no express ban on the advertising of personal injury legal services or medical negligence legal services, specific prohibitions and limitations do exist. Where they do, I suppose, most clearly manifest themselves would be where, so direct prohibitions would exist on any express or implied reference to claims for damages for personal injury. So, any advertisement that would say, we will get you the highest award, or where there's blame, there's a claim, that kind of language, that's prohibited. Any inducements to making claims for damages for personal injury where, it might say, oh, if you can get this, you might be offered this, we'll get you that. That's prohibited. References to no win, no fee, first free consultation, anything that is acting as an inducement directly to persons is prohibited. But generally, personal injury can be advertised, but there needs to be a disclaimer placed. So it says where in contentious business a solicitor may not calculate fees, or so there's a direct disclaimer that that must be stated. In terms of disrepute, there are, as it says, a solicitor's advertisement may be considered one that may bring the profession into disrepute where it contains words or images that would lower the general public esteem for the profession. And that really is one of the key objectives for enforcement, just to preserve the integrity of the profession. But as said, it's quite generic, and so I wouldn't specifically state that something is or isn't capable of bringing the profession into disrepute. It would be referred to the Regulation and Practice Committee, and they would make that call. And as it says there, I have incredible examples where, and I've just got one on this slide, where people have said, websites have stated things like, nursing home abuse is on the rise, don't let granny get it, call today. So, any kind of thing that might, refer to, it's generally medical negligence, personal injury, or any vulnerable persons that might be considered capable of bringing the profession into disrepute would be restricted. Bad taste, again, that's another one that is very objective, and as such then any risk that there might be for this to exist would be referred on to the committee. And they're just really examples of they're more American than anything, just classic examples of what would constitute bad taste. Again, really, to reflect unfavourably on the profession, I think that where solicitors maybe are engaged in sharp practice, they would be quick to say that isn't the case, that that they're not advertising in a way that might reflect unfavourably. And again, it really comes down to the committee to decide on whether that is or isn't the case. In any business, the protection and preservation of brand integrity is the key to success. And with the provision of legal services, the legal brand is intrinsically linked to the fiduciary duties of trust and confidence, honesty, the highest standard of care, and always acting in the best interests of your client. And so that really needs to be preserved, and it's that kind of framework of thinking that's kept in mind whenever the subjective notion of something reflectably unfavourably on the profession is enforced. Purporting to have knowledge that's superior to other solicitors, that's quite a common one as well, where simply put, you are able to state on your advertising that you are specialised in a particular area of service or of practice, but that you're not the best in that. So you can say that you specialise in family law, but you're not the best family law solicitor in Mullingar. And I mean, it's obvious why that is the case. It's to, again, maintain a level playing field amongst the profession. Hi. Yes. Yes. Yeah. Okay, I'm just going to try and match this. Okay, yeah, this particular slide I just wanted to identify it with you today because distinction needs to be made between a advertisement and then a communication that's intended to provide information on the law. And most recently, the best example of that distinction has occurred with the recent cervical check controversy. And so where a lot of my work over the last year has actually been investigating solicitors who have been advertising their professional services in respect of that, and where certainly, yes, a solicitor, and it's common practice for a solicitor's firm, particularly if they specialise in a specific area of practice, to update their clients or prospective clients on matters of the law. Commentary is permitted. Recent case law is permitted, but what you can't do is to then frame your legal services alongside that or around that. So to say, oh, this has happened, this award was given, if you have been affected by this, then contact us. So there's just a fine line that needs to be drawn between providing commentary or providing information, and then advertising your professional services in respect of that. I'll just quickly flip. I mean, you have all of these. These are just examples of graphics and cartoons, permitted imagery, what would be permitted, what wouldn't be permitted. For instance, these images, they obviously would not be permitted because clearly they demonstrate a person in a state of distress. That said, road traffic injuries is commonplace, and it's a huge area of litigation. And so what you could illustrate or publish on your website, for instance, would be two cars colliding, or one car that's broken, but not where a person is in a state of distress. We're understanding for the fact that firms need to have websites that are engaging, that are stimulating, that are attractive to look at, but at the same time they can't go beyond the bounds of taste, I suppose. So they're just examples of stock images that would be permitted. I'll just fly through this. And finally, yeah, it's not there, but just to let you know really about the future for the advertising regulations, Section 218 of the LSRA makes provisions for the regulation of the advertising of legal services. And as I said before, although this section hasn't yet been given a commencement date, it's still it's imminent, but until then the 2002 regulations very much represent the law and as such are being enforced as that. So I think generally in terms of the profession, compliance is very high. I'd say maybe around like 95% of the profession is generally compliant, and that 5% that isn't, it's the same kind of repeat offenders who keep coming up again and again, and in the same areas of specialisation as well, and it's they who I think are rubbing their hands with glee at the inevitability of the LSRA coming into force. But really what needs to be said is that the spirit and the intention of the 2002 regulations are very much maintained in the 2015 Act, and not alone is that the case? But the 2015 Act also makes provision for other regulations to be drawn up if appropriate. So really, the last thing for me just to mention is the vetting service that I provide. As I say, the society is sensitive to the commercial realities of practice, and then also print and media deadlines and the potential cost implications that arise. One example of that is I had a recent firm where they had signage, they'd erected signage, and so the cost implications of having to change that are quite considerable, especially if you're setting up in practice and it's a contingency that you maybe hadn't anticipated, that sign then needs to be taken down and re-erected. So we're sensitive to all of those issues, and as it said, a cooperative approach is adopted. I much prefer to work with solicitors than to kind of come down hard, and it just it doesn't really get you anywhere. So really, that's everything.
Morning, everybody. First, thanks for having me here to discuss this. Nobody really wants to talk about insurance ever. Never know on a Saturday morning, but we'll try and get it through as quick as we can. Just a bit about me. My name is Terry Dunn, First Oil and Risk Management. We act as a broker to about 160 law firms in Ireland for professional indemnity, and also about 600 or 700 barristers for the PI. So we would be known as a specialist broker in the law division. We're uniquely placed. We're on Parkgate Street between the two main courts, so geographically it's a great location for us. We've got footfall of solicitors and barristers coming in. So look, we'll try and go through this not as quick as possible, but as easily as possible, I suppose. I've got a couple of bullet points, nothing too spectacular to go through. The solicitors PI market, it's a bit unique in how it works. It's not just talk to anybody, any broker that you wish to talk to. There's specialist brokers that deal with it. Insurers won't deal with every broker. There's probably a panel of maybe 10 or 12 brokers who really are involved in this, and there's participating insurers. So each participating insurer needs to sign up to the minimum terms and conditions wording. It's not just any insurer can come in and decide, I'm going to write PI for solicitors today. They need to know what they're doing. They need to be signed up to the wording prescribed by the Law Society. So PI has had a bit of for solicitors, had a bit of a troubled past in Ireland, particularly around the boom era, where property was just going up and up, conveyancing was just being done cheaper and cheaper and as quick as possible. So mistakes were made on both sides by everybody, and as a result, when the crash came around, claims started to really come in for massive amounts. The property, as it was going up in value, people were just saying, it's never going to come back down. We don't need to pay as much attention to the work that we're doing. And when it did crash, banks came calling, people came calling, looking for their money. Where's my undertaking? Why is this not fulfilled? And for various different reasons, the undertakings weren't fulfilled. So massive amounts of claims came in. Insurers were badly burnt, and it took the insurers and the Law Society to work together to come up with new policy wordings that were tighter, less favourable to solicitors, and would entice insurers to stay within the market as much as they could. Unfortunately, an effect of that was premiums jumped from a premium of about €4,000 to a minimum premium of close to €20,000 at one stage, which put a lot of small firms on the back foot from day one. The insurance would be one of their biggest creditors, if not the biggest creditor that they would have from day one of starting up the practice or running the practice. So it was very difficult. Again, a unique thing to the solicitors market is the common renewal date. Every solicitor renews on the 1st of December. Whether you take your policy 1st of February when you start your practice, you will run to the 1st of December. Generally speaking, they will offer it on a pro rata basis, which means they'll take the premium, divided by 12, whatever's left, subject to a minimum premium of 50%. That's a rule of thumb, but it's not set in stone. Again, I touched on the common policy wording. Every insurer has to sign up to the prescribed wording, the minimum terms and conditions as it's called. There's no getting away from that. There's a difference in conditions clause. If any underwriter does try and be sneaky and change the wording, it will refer back to the conditions set down by the Law Society. So you can always be assured that the wording you're on is the same as your colleagues that are out there. You're not getting any less of a wording. Brokers have specific relationships with insurers. Not every broker has access to every insurer. Mostly it's done that one broker deals with one insurer. So you're going to us, for example, we only deal with one insurer. You go to another broker, they won't deal with our insurer, they'll deal with a different insurer. So it really comes down, when you're shopping around, to make sure that you're only dealing with a broker that deals with that particular insurer. There's no sense in going to another broker that deals with the same insurer as us, and the Law Society provide that list on their website to say what broker deals with what insurer and who has access to who, to save you effectively wasting your time. You don't want to be bombarding the market. If an insurer starts seeing your risk coming from 10 different brokers, they're less likely to look at you than they are where they've seen it from one specific broker. They know you've spent a bit of time and looked into the matters that need to be. The majority of the participating insurers write on the primary policy only. That's a 1.5 million limit of indemnity. That's the set down limit. They can't do any less than that unless they are on a co-insurance basis with another participating insurer, where they might take a 50% or 60% share of the risk. Now, you can buy higher than the 1.5 million. It's called an excess layer, and you do not need to be a participating insurer with the Law Society to provide that cover. Any insurer can provide that, as long as they again stand over the minimum terms and conditions that are set down by the Law Society. As it stands at the moment, there's no direct access, and what that means is that you can't ring up AXA or AIG or whoever it might be. You do need to go through a broker. There was one company who wrote it previously. They're no longer with us anymore, but they were the only ones who've ever really done the direct access. A common thing that comes up when people are talking to me about starting their practice or even at renewal stage is, where did that price come from? So there's a number of factors that come into it. Generally, the main thing is your income. The income of the firm is how your policy is directly rated, and within that income then you'll be asked to split out your type of work. So you might have 10% conveyancing, 20% defendant litigation, whatever it may be. Each of those types of work has their own set limit or set rate that's applied to that portion of the risk. It's then rated up, they're all added together, and your premium is rated that way, subject to a minimum premium. Some of the risks are much higher. We'll touch on that later on. Conveyancing, for instance, carries its own particularly high rate. I'll go into some of the stuff later on the actual rating. So the income in the previous year is really how it's rated, because that's a reflection of how you've done in the year, how much work you've done. The higher the income means that you've done more work. Now, when you're starting off your practice, you will need to give an estimation as to where you plan to be within that year, and that's the figure that they'll use to rate your firm. So that's really that. Most premiums, all policies will be subject to a minimum premium. At the moment in the market, last year it was probably close to about 3,000 would have been the minimum premium starting off. My view this year, now I don't have anything set in stone as yet from any underwriter, but I do see that increasing this year. The reason being is there's been 2 insurers who will not be renewing this year, so there's going to be a tightening of capacity. One of those was a fairly significant underwriter. They had a large portion of the market. They were called AmTrust, and they've just decided this year that they don't want to renew their book of business. Now, the broker I know is looking around for an alternative market. I'm not sure if they've sourced anything as yet, but with lack of capacity, generally it comes higher premiums. That's just a market function. It does happen. There are some ways you can get your policy rated down. You can have a higher excess. Insurers like to see you having some skin in the game in a sense, essentially. So if you want to say, well, I don't want to carry an excess because I can't afford to pay it, you're asking the insurer to pick you up from ground up, that it seems that you don't really care about this too much, and sure, the insurance will pay it, and they're going to rate you higher as a result of that. Coming to the topic of today, setting up a new firm, I can't really stress enough presentation. If you give in a half-cocked submission that you don't really care, you've skipped questions in the proposal form, you've put together a business plan that consists of 10 lines, I will be doing this, I'll be doing this. Insurers are going to gloss over your submission. You know, they're just not going to waste the time. They're going to look at the one. If they have two submissions in front of them, one that has everything hunky-dory, has all the CVs, has a good business plan, set out logical way of looking at the firm, they're more likely to look at this risk and give him a favourable premium. They might quote you, but it will come into the factoring that your risk, you haven't done what you should have done. You haven't put it together in a way that would look well to them, that shows that you're serious about this. So there's certain things, the common proposal form, this kind of scares everybody when they get it. It's 19 pages, I think, this year's proposal form is, and there's 16 sections within that, but some sections have up to 32 questions, and some of them can get quite long-winded. People think, oh, that's not for me. Every question is for you. Do not miss anything. Even if you say, well, I haven't done any work, the way it's worded is, have you ever? And people say, well, I've never done anything, I'm only starting off. Answer it as if you're thinking into the future. Will you do this? So again, never skip a question on it, or if you do skip it, give a rationale why you've skipped it. There's a form for additional notes within the proposal form. The business plan, again, they don't want to see you write 10 lines of, I will do this, this, this. They want you to set out a clear rationale as to where you see the firm going, what you're going to do, what your specialty is going to be, where you've come from, why they should write you effectively, that this is a viable business going down the line, that you're not going to be gone in 6 months' time, and that they've spent all this time writing this business, you look to cancel or you don't renew, or wherever it may be. An important thing that you will be asked for every submission as well is a CV for all partners, whether it be principal or partner firm. And again, they don't want to see qualified here, worked here for this. They want to see what you've done when you were in these firms. If you were in a large law firm that you've done commercial litigation, or wherever you might have specialised in one area, brevity is not your friend with these documents. You know, you need to give a bit of detail on them. And again, coming back to the business plan, an overview of where you see the firm going, so that you're in this for the long haul, that you're not going to just jump out, oh, this hasn't worked for me within the first 3 months, that you do realise this is not here going to make my millions in 3 months and I'm gone then, that it's a long haul game for everybody. Again, going back to the submission, create the right impression, as I touched on, the form is very, very long-winded. The good news is that you will really only have to complete it once. Most insurers now have a short proposal form for renewal purposes, which consists of about 4 pages, which captures information as to what you've done in the first year that you've worked. So your work split, have you taken on any additional staff, have you had claims, is there any issues that you're aware of, and again, to create the right impression, after your first year, when you've got in and you've done some work, a risk management review done by a third party is help you know when to get your premium down. Insurers love to see that you have spent money looking to get somebody in, a third party. I won't name any specific ones, but there are some very good risk management firms out there. They'll give you a score. The higher the score, the more favourable the insurers will be in your premium. And again, the insurers are not here to gouge for premium. They're genuinely not. I've been on both sides of it. I'm kind of unique in where I am. I've worked both underwriter and broker, and I can tell you that the underwriters they do look to try and get the premium as fair as they can get it. There's a lot of actuarial work goes into getting out these rates. It's not just plucking numbers from the sky. Oh, well, he paid 4,000 last year, we can get him for 3,800. It's not that situation. They do put the work into it. Again, going over how the premiums are calculated, so going over the form again, I don't want to keep going on the common prop, but make sure all the information is fully completed in your proposal form. The claims history of the firm, again, that's really for firms who have been established, but if you're setting up, do advise the insurers that if you had any issues, whether it be disciplinary, whether it be a claim was made against you in your previous practice. Now, it shouldn't come into the rating of the firm, but again, if you can demonstrate that you've had a clean history whilst you were employed elsewhere, it will stand to you. The underwriters are more likely to give you a favourable quote if you've demonstrated that in your 10 years of being employed that you had a very clean record, no complaints against you. It's easier for them to get a quotation. Categories of work. insurers wouldn't like to see in a startup firm somebody jumping into large commercial transactions or M&A work or stuff like that. It's not on target for a lot of insurers. There are some insurers who quote it, but the premium will be commensurate to the work that you're doing. So my opinion is, or my view is, that if you're starting off, kind of set your targets a bit lower to where you're going to head off, unless that's your specialty area and you are going to be accepting of a premium commensurate to the work that you're going to be doing. The number of partners does come into it, because some insurers won't quote sole partners. They just don't want to do it. That's not sole principals. They're just not into it. That's not their area. They've had horrendous claims in the past. They do like to have a minimum of 2 partners. There is insurers that will quote 1, but it's kind of limited to 1 or 2 insurers who will look at that sort of risk. But generally speaking, the more partners, the more control there seem to be, hence the more insurers that will likely quote you. The rating is directly related to the revenue, as I said, so the higher you anticipate your revenue to be, the higher the rate directly applied to that revenue will be. And again, I'm not saying fudge your figures when you go in, that you just say, oh, I'm only going to earn 100 grand, well, you really know yourself that your estimate is going to be 500 grand, because it will be caught on the back end in the following year where you're rated retrospectively. So you're not going to get away with just saying, oh yeah, 50 grand is my target, wink wink. You know, that's just not going to happen. You have to pay the piper at some stage. Okay, to just give you some overview of how underwriters view what is low risk, what is high risk. You can see some of the stuff up there on the board. The low risk work, particularly criminal. If you lose a criminal case, the person's very unlikely to sue you because they're either in jail or they've no money left. Expert witness as well, you know, it's an opinion as opposed to anything, you know, it's again unlikely that something will come in. Or immigration, the PI policy is picking up a financial loss that somebody's had. That's the basis of what it's supposed to be. So the low risk work, there's low risk of a financial loss to somebody. The medium risk, as you see, there's some there, you're kind of stepping up a limit there, where if you mess up a personal injury claim, such as a missed date or a statute or something like that, you have cost this person potentially some money. So then you start to get into where insurers are looking to apply a proper rate as such, to not a minimum premium as with the other one. A lot of insurers will still look at the high risk stuff, estate agency, trust wills, probate. Whilst they do have claims, a lot of the claims are ordinary decent negligence, where you've simply missed a date, or you have quoted the wrong statute or something within the document, or relied on the wrong case law or something like that. So was they will look at it, it will attract a higher rate. Stuff that a lot of insurers are not in the very high risk is commercial work and conveyancing. Conveyancing has had a massive impact on PI insurance in Ireland. The losses to insurers, particularly, you've had a lot of insurers who have withdrawn from the market over the years, and as a direct result of their conveyancing claims. So you have a lot of insurers now who will not take you on if you have more than 20% of your book is conveyancing. They're just not really into it. It's too high risk for them. Now there are insurers who will still do it, but again, the rate will be commensurate. If you go in and say, I'm a 100% conveyancer, that's all I'm going to do, they will rate you quite highly, and just be prepared for that. Now, whilst the work may be there at the moment, with the economy improving and the properties going up again and houses being sold, you will probably get a living out of it. Bear in mind that the PI insurance will be affected as a result of what you're doing. I've just given some brief examples of claims. You'll see them in the document there now. Neither of those, or any of those 3 claims there, would not be considered a massive claim. I didn't want to scare anybody by putting in examples of 3 million losses or 4 million losses or anything like that, but those losses do appear out there, where the primary insurance is burned all the way through and the excess layer insurer is brought in then at that stage. But a lot of claims nowadays, I mentioned earlier, are ordinary decent negligence, where somebody misdates, misstatute, they can't fulfill the undertaking that they've given to a bank or something like that. But Probate is another area where there's a lot of claims come in, where a will is shoddily drawn up, or they leave out a beneficiary, or there's a family that nobody ever knew about on the other side of town, or things like that. And it does come up, and the claims, again, when you're dealing with an estate, they can be quite big. You're getting the average estate where you take into houses or cars or wills or life insurance or anything like that. They can touch on $1 million fairly easily, so your primary limit could be burned through fairly quickly. So if you are doing probate, consider the value of the probate that you're doing, and that you may need to buy into an excess layer insurance, that your 1.5 million may not be enough. And again, that goes with conveyancing as well. If you're doing a transaction for a property that's worth 3 million, your 1.5 million, in the event that something goes totally wrong, it's not enough. You're simply going to be on the hook yourself after that. So do consider the excess layers are quite cheap to buy in comparison to the primary. General rule of thumb.
Can I just ask you a question?
Yep.
On that? Probably to a broker yesterday about conveyancing. I'm just wondering, for commercial conveyancing, is it so important if you're selling to increase your...
It is, and what's happening now is if you're doing the work for a commercial conveyance, they won't let you do it unless you have the limit in place.
Even if you're just selling?
Even if you're just selling. There's a lot of them won't let you do, and it won't deal with you if you haven't got cover commensurate to the value of the property. Now, you don't have to have it. It's up to yourself. If you want to walk away from the contract, if they won't let you do it, fine. There's nothing to say you have to have the cover up to the value of the contract to do, but I'm myself, I'm a risk adverse person. I would consider it before I get involved in any contract. I wouldn't expose myself to, that's just the way it is. But a lot of banks or sellers or buyers won't deal with you unless you have that cover in place. And as I said, you need to weigh it up. If you're doing the contract and you're earning 5,000 from it, and you need to buy an excess layer insurance that costs you 1,000 per year, you will need to maintain that for a minimum of 6 years, depending on what's in the contract that you have. So,
I have an example for a sole practitioner. It's going to be non-viable. It's a case of selling a building for $8.5 million, and I asked broker what would it cost to increase the premium. It's an increase of 8,000. But I was thinking, well, that's not too bad until she reminded me that I need to follow
Yep.
6 years.
it is something to keep in mind. Now,
So it was going to be an extra 50 grand.
yeah. Now, you're not buying it just for that thing to consider is you're not buying it just for that transaction.
I wouldn't have too many-
So you can put yourself out there as having that limit and tender for that type of work, but you're right, it's not viable for some practices to buy the insurance. And unless you can come to some agreement with them that they pick up half the cost of the insurance or whatever, it's unlikely they will, but it is something to bear in mind. Don't think, it's only costing me £2,000 to get 3.5 million this year. It's not costing you £2,000, it's costing you £2,000 by 6. So if you're earning 10 grand, it's not economically right to do it, and if you decide, we'll keep it in place for this year and reduce it next year, you're in breach of the contract. You signed a contract saying you have this limit of indemnity. So if something does come down the line and it goes wrong, and you only have the 1.5 at the time the claim is made, because PI is a claims made policy, it's the limit on the day the claim is made against you, and the policy that's live on that day. Not, I had 6 million cover at the time we done this transaction. Doesn't matter a jot. It's what's in place on the day the claim is made against you.
How long do you have to maintain?
It depends. But generally speaking, it's 6 years is what's in it. But there's an argument in PI that the statute doesn't really start ticking until you discover the error 6 years from then. So it could be 20 years down the line that you still need to maintain this cover. So it's something to keep in mind. As I said, the excess layers, the general rule of thumb is that they run at about 1,000 per million over the primary cover, depending on the firm involved. But if you're dealing with an average startup firm, that's kind of the figure that you're looking at. So,
will anybody do a policy for that one transaction?
it's unlikely they will.
I think maybe about 40 years ago, I think you could.
It used to be able to do it. It used to be, but what happened then is during the boom time is every transaction was starting to run. People ringing up, oh, I want to increase it for this transaction, this transaction. So all of a sudden you had 40 transactions that you had it. So insurers took the view that it's not, the policy was getting unwieldy, and there was 40 endorsements on the back of it to say transaction on Blackhall Place, increased limit of indemnity of that. So in effect they were getting to that exposure anyway, and they weren't getting the premium commensurate to the risk that they had. So they rolled back and said, no, okay, if you want that excess layer, we'll apply across the board. So any other questions on the limits? I can see you mulling one over in your head there. Okay, just a bit about the cover. Now, this is a very brief view. The policy wording it's quite long-winded, so obviously I wasn't going to go through every bit of it, so I tried to extract the main points of what you're covered. So the policy is written on a civil liability basis, which is, in insurance terms and PI terms, as broad as you can get. You get dragged in on something even if you're not fully wrong. Somebody else is messed up here, they've no insurance, they go running, you guys are landed with the claim. Now, not so much on solicitors, that happens in other professions, but it can happen where a planning consultant was involved and they got the planning documents totally wrong. All of a sudden they're gone to Australia, the house can't be sold on, or there's a loss of opportunity or something like that as a result of not being able to complete the sale. They're going to come knock at your door and say, you're the last person here, you were involved in this transaction, you sort of spotted this, and because you might have spotted it, you could have spotted it, you could be saying 1% wrong, civil liability, you're all wrong, you're dragged in, and the full payment will be made under your policy. It's quite broad, the cover, that, and it's good for you, it's not so good for insurers, but it's in the minimum terms and conditions that they have to write on this basis. There are some things within the policy wording of claims noted as historic, which is work you may have done in the past, you could have known about it beforehand, and you don't have continuous coverage with if you maintain with the same insurer. But what insurers are doing now is that was stopping business transferring from one insurer to another, because they were saying, well, if I move from you, I don't have my continuous coverage, which means a claim that they should have notified in policy 2014, if they were still with the same insurer in 2018, the 2018 insurer does have to pick up that claim, even though it's a claims made policy. But if you switched insurers in the meantime, and the claim was made on the 2014 policy when you were with insurer A, 2018 you're with insurer B, unless they've given you the continuous coverage clause, you'd be on an uninsured basis, you know. But 90% of the insurers are now given the continuous cover. So that comes in, if you are thinking of switching insurers, always make sure you've got the continuous coverage clause. Defence costs, which can run sometimes higher than the actual indemnity payment, are covered in addition to your limit of indemnity. So that's regardless of, even if there's no indemnity paid and they fully defend the claim, which can run into six figures quite easily, with solicitors, barristers, specialists involved. They are in addition to your limit of indemnity. Generally speaking, if you have a claim that's been successfully defended, even though there's a claim payment of, let's say, 100,000 on defending the claim, new insurer will not really hold that against you. They shouldn't anyway. You haven't done anything wrong. The policy is done what it's designed to do. It's there to protect you. It's there to protect the public. It's there to respond to these matters. So if you have had a claim and on your claims experience it says 100,000 payout, make sure you get someone from your insurer to say that it was defence costs only and it was successfully defended. I've stuck in psychological injuries caused by you because, generally speaking, on a PI insurance, bodily injury and property damage, all those sort of things are excluded. But psychological injuries, which do fall under bodily injury, can be covered if it's as a result of your negligence, that somebody lost their house or their business as a result of your negligence and they've been psychologically affected. It is classed as an injury, which generally is excluded on the PI policy unless it's as a direct result of your negligence on the contract you were dealing with them with. Unfortunately, there's a lot more that's not covered, and that's a brief overview of what's not covered. So the insolvency of a financial institution. Take that for instance, that somebody places a mortgage, you help them with a mortgage into whoever it might be, Stepstone Mortgage, and trying to think of somebody who's gone in recent years, and now their mortgage is with a vulture fund. Well, you helped me, you told me that Stepstone were fine, you done all the due diligence here, I'm now with a vulture fund who are out to get me. It's not really a case that the PI policy would look to pick that up. Another one is, if you are, a lot of people do have outside directorships where they might have an interest in the firm. If you're acting for your own firm, it's effectively, the policy excludes you from suing yourself unless the claim emanates from an independent third party. So if the firm that you're a director of, if you act for legal services for them, that firm cannot sue you unless that claim has arisen from somebody outside of either firm. There's some obvious ones up there: trading loss or personal debt. The firm lost money in the first year, technically it's a financial loss. There have been people who have tried it in the past to say, as a result of my poor work, I haven't made any money. So when my PI policy picked it up, it was chanced. Fines clearly not allowed to be insured, and damages in relation to them. I said there's some other ones there. A very key one actually is undertakings in the course of a commercial property transaction. The cover can be bought in, but it's generally excluded on the general policy that's issued. But you can buy the cover at a higher limit of indemnity, at a higher premium. A lot of people don't buy it, but they can. It is out there. Some insurers will offer it, some just say no, we're not interested. If you're going to be doing that, you need to be with a different insurer. There are some insurers who, as I said, will write the higher risk stuff, and some who are just not interested in it. And an obvious one then, touching on stuff that may have happened in our recent history, fraud and dishonesty is totally excluded on the policy, which is only fair, to be honest. So that's me. I'll take any questions from anybody, if anybody has anything. Yeah?
What's the role of the IT systems?
Yeah, the solicitors' IT systems, is it? So the diary systems are key. I mean, if you, again, this will be in your business plan, or should be, that you intend to use whatever diary system or whatever case management system. Old file, paper file handling, insurers don't want to see that. You know, it's not feasible in this day. There's no need to do it in this day and age. The software that's available out there is fantastic. I see one outside on with the advertisement out there, and it's everything done for you. You know, you don't have to worry about arriving at court. Oh no, I've left my file back in the office, I'm gonna have to wing this. It's there on your phone, or it's on an iPad or whatever. But the key one is the diary system. I would just say your diary system is the most important IT thing that you're going to have in relation to your PI insurance. It keeps track of everything, reminds you of statute dates, all of that sort of stuff. It is a major thing going forward, and that's not just specific to solicitors. This is every business. And I was at a conference recently, and the opening line from the guy was, there's two forms of people in relation to cyber attacks. There's people who have been attacked and people who will be attacked, and there's no way of getting away. No matter what security you have in place, you're susceptible to anything. You just look at the likes of BA, Facebook yesterday. These guys have technology, security in place that none of us will ever have, and they were still breached. So these hackers are one step ahead of you. The conference I was at, they showed us a website where it looked like eBay, effectively what it looked like, but they were selling personal details of people. So a solicitor was going for 100 quid, or a janitor was going for 20 quid. You know, it was crazy stuff, and you'd be shocked. You'd most likely find yourself up there. You'd be surprised. But there are ways you can buy cyber insurance. It does. It will have a good effect on the underwriter's view that you're serious about your risk management. It's cheap as chips at the moment, cyber insurance. It's not going to last that long. You can get a decent policy for about 600 quid
No, you're fine.
There is a cyber section within the proposal form, yes. It doesn't go deep into it, but if you demonstrate that you've got a good cyber policy in place that has access to, most cyber policies now will give you access to a panel of specialists. Should you have a breach, you pick up the hotline 24 hours a day. They will remotely get into your system, try and get these people out. If not, protect as much data as possible. Because if you lose data, potentially your clients are going to be affected. They will lose a contract or whatever it may be. That's a PI claim, which can be picked up under the PI policy. But if the cyber policy is there to protect that and stop that from happening, it's obviously mitigating the loss to the PI insurers, and hence the premium can be looked at favourably then.
How are we? All right. Morning to you. My name's David Rowe. I'm from Outsource. So, first question is, who are we? This is what we do. We're business advisors to law firms. That's the only thing we do. We're independent, so we're not tied to First Ireland, to Expediate, to anybody else. We're advisors to you guys. We're the sole provider of what's called the Law Society Subsidised Practice Advisory Session. So once you start up, you will be written to say, this session is available, 4-hour session with me for €150, where we cover things I'm going to show you in a minute. There's a lady here, she asked me to allow her speak for 10 minutes on how brilliant the session was. It was good, was it? It was. Yeah, so thank you. Yeah, that's that tenor owed. So you'll be written to once you start. Once you start.
Marrying her?
What?
When are you marrying?
After we both get separated. Yeah. There's a little complication first. So you'll be written to see, do you want to do this session? When people see the words Law Society on it, they think scary, regulator. And of course there's the regulation and the representative side. We're independent from the Law Society, and we've an obligation of confidentiality to you as the taker up of the session. It'll say that you have to pair with somebody else or have somebody else there to get the CPD points. We can do the pairing. It works quite well. This lady did a session with 2 other practices in Dundalk, and that actually worked well. You guys learnt off each other actually at the session and kind of addressed some common challenges together. We're the largest buyer, seller and merger of practices in Ireland. So, we buy, sell and merge more practices than any other provider. That's our specialist expertise. We're not an accountancy firm pretending that we do this alongside a compliance service. There's somebody who had actually registered for this who's not here. And recently, for people that are thinking of setting up, he came to me, said, look, I want to do an hour with you. Tell me about how, what's going to make a difference and whether it works or not. What are my options? Sat down with him, spent an hour with him. He then said, look, based on your analysis, I think it's a really good time to buy a law firm. I said, I agree with you. He didn't have deep pockets, as most of you won't. I identified 2 practices. They weren't on buy, sell, merge or anything like that. These were ones I knew off the market where people were maybe coming towards retirement, but they're not prepared to put their name on a website or a trade thing. So, there are people I approached that I would have known that would have come to me to say, look, if you find somebody, I would think about this over the next 2 or 3 years. I acted for this guy, so we met the vendor twice. I advised him. We made an offer. I did bank project and business plan projections with them. We've agreed terms with the vendor, and I've done the agreement to buy, and I've charged that fella for all of that together less than €1,000. So we take a view on startups that you're going to be a client of ours for life if we give you good service. So the first session will cost you £100, £150, something like that on what are your options, and you'll get pretty good advice, I think. But you should do the Law Society sponsored practice advisory session anyway, or maybe as well. It's a really good session. I write regularly in the Law Society Gazette, etc., Parchment, all that kind of stuff. And we operate for people outside Dublin. We operate right around the country. This lady's in Dundalk. I'm in Sligo next week. I'm in Galway next week, and I'm very happy to. My wife thinks I have. If I don't get a day outside Dublin in the week, I begin to get itchy feet, and she's probably right. Well, she is right. Okay, so how do we help? We can help you with looking at your business plan before you start. Is it likely to work for you? So what Keith said to you earlier on, some very good advice on that. Will you make a living from it? So, that's the big one. Are you going to make a living? Are the elements in place? I'm fairly straight. If you come to me for a session and I don't think that you have the ingredients to actually make your practice into a profitable practice, and you want me to tell you, I'll tell you, because I think that's giving you a good service. And if I go into a practice that started up, one of the saddest things for me is to go into a practice where somebody's just started up and I'm looking at the person saying that person's probably not going to make it because they don't have the core ingredients in terms of what it makes to build a successful practice. And my instincts are pretty good. I suppose what I'm seeing at the moment is that people are setting up practices for positive reasons. So we've done this Law Society half day subsidised, which is our brilliant half day, for 10 years at this stage. It's 9 years, since 2009. What I saw in the early stages of it was people who were coming to me because they'd been let go by firms, where firms had to downsize. Their existing practices had no choice. They had to downsize. So it was almost like a negative startup. What I see now are positive startups. People want to they see this business opportunity at the moment. They see that they are going to make a living out of it, and they're setting up because they're making a deliberate career choice rather than they're being made redundant by somebody else. So that's much more positive, and there's been a whole change in that since over the last number of years. So what we do, we talk to you about the obligations you're taking on and how best to equip yourself to deal with it. We help you with cash flow projections. We talk to the banks for you. We tell you what you'll be able to borrow, what you need to have yourself to put into it in terms of capital. We'll help you identify potential takeover opportunities. That could be through buy, sell, merge, or it could be ones that we know that aren't on the market but that really are on the market, but are sort of sitting on the fence. Will I, won't I? Well, if you can get me a buyer, I'd sell, but I'm not going to put myself out there publicly. That is always a worry. We've a lot of firms who want to merge with each other. We've a lot of older practitioners. There's a huge raft of older practitioners in early 60s looking for exits, and they're a fantastic buy at the moment. So the one I was telling you about earlier on is not a huge practice. It's billing about 150 grand a year. I want to contradict something the previous speaker said in a second, so if I don't do that, remind me of it. Not a huge practice, billing 150 grand a year. Now that's a decent practice, probably has potential to go on further. I definitely think it has potential that the current practitioner is tired and hasn't been chasing work for a while. It's in a good area, good catchment area, mostly conveyancing, which is what I want to contradict this guy on, and a little bit of PI and quite a good probate practice. I want to contradict him on that one as well. But we've paid there 20 grand in goodwill. So goodwill is you're buying the name, you're buying the wills, etc. And we're paying 20 grand for the work in progress, other than 7 big litigation cases where we're splitting the fees on the basis of the practice that's selling has done X percent of the work up, and the practice that's buying will do Y percent of the work, and we've a look back at the end when the fees come in, and we'll pay the vendor their percentage. And if we can't agree those percentages, we go out to an independent cost accountant who'll say what the percentages were. So this particular individual for 40 grand down is getting a whole live practice. Okay, now 40 grand's a lot of money, but he's got immediate cash flow coming from the fee income of that old practice. And one of the challenges if you set up from scratch is without a practice is that it takes you quite a while to build the cash flow and the work in progress on the files. So there's a direct correlation in law in the legal business between how long the money takes to come through and how profitable the work is. So all the less profitable work comes through quickly. District court, family law, and then go up the scale. Conveyancing, 3 to 6 months. Probate, 9 to 15 months. What am I talking about in the months? I'm talking about from when the... I wish I had an hour, not 15 minutes, Keith, but anyway. Talking about from when the thing starts to when you get your cash flow in. PI litigation is where the jam is, but you've got to carry those for 2 or 3 years. So if you set up a startup practice with no cases coming forward from another practice, your really nice money, which could be in probate or PI litigation, is probably either a year or 2 to 3 years away. And that's one of the challenges, and that's why it makes sense in particular circumstances, if the buy is right, to look at buying a practice. Okay, so we've lots of older practices looking for somebody like you to take them over. This session isn't about, what to look for, but we do all that. And there's lots of situations you wouldn't go near a retiring practitioner, but there are many situations that you would. So we advise on partnership arrangements. We advise on practice management systems. We're an independent. You look at the demos. You'd be blitzed. You think they all look brilliant. You'll say, "Wow, that does everything that I want." But then you'll find out 6 months down the road that you actually made the wrong choice, or that you were overwhelmed by the presentation and the slickness of it. But actually, had you talked to a number of colleagues or somebody like us, you would have known this wasn't the right system for you. We advise on PI, but we're not a broker. So things I disagree with on the last speaker a little bit is that, we don't completely disagree. There's a lot of really good content in it, to be fair. I mean, it's not realistic for most people in the room to start up a new practice now and aim to take in less than 20% conveyancing. And the insurers know that, and they live with that. The key thing is you've got to demonstrate that you have the right controls not to make the mistakes of 15 years ago. So, I saw people writing down notes 20%. Honestly, most, particularly private client firms, are up at around 45, 50%. And the insurers live with that. They know that, but they want you to have the controls in place, the risk management controls. And most of you have come through a kind of a slightly different environment as well, where we've had a PII crisis, and you've probably learned from the mistakes of maybe you've made some of the mistakes even on behalf of your previous or current employers, but most insurers do not also see probate as high risk, which was on the slide. They see it as medium risk. So probate and conveyancing are likely to be the bedrock of most practices in the room, and I wouldn't like you taken from that session that you should stay away from them, because you will, if you're going into private clients, you will have no business. You won't earn an income if you stay away from them. Okay, we advise on regulatory. This is what's in the. All of this stuff here is in the practice advisory session, which is subsidised by the Law Society. It's highly confidential. It does work. This lady will attest to have 2 or 3 in the room. I'm very happy to do it on a one practice only basis. If you want the CPD points, you need to bring another person along with you. But we can arrange that. We do sessions where we take 2 or 3 together. So it goes through the regulatory and compliance. There's a much lower level of tolerance now in regulatory. Okay, and the days where you had to run off with your client funds to be in trouble with the Law Society are well gone. Okay, so it's now very much compliance based. I've seen somebody up recently, for example, for not establishing the source of funds on anti-money laundering. Did absolutely nothing wrong, just in the Law Society's view, didn't do enough to establish that we were on the source of monies, even though the monies were coming from another solicitor, which is a little bit strange. But so comprehensive look through the solicitor's accounts regulations, quick look at risk management, we look at anti-money laundering. We also look at the common concerns, the common mistakes, and I suppose another way of putting that is where the profession fall down typically, and when the inspectors from the Law Society come in, the typical errors that they find in practices, be they at start-up stage or further down the line. We walk you through the regulation process. You would have heard that earlier. We talked to you about choosing an accounting and practice management package. What's out there? What's there for your size of practice? Each size of practice, startups now have 2 or 3 good options. Okay, you're going to see one of them shortly. They have 2 or 3 good options, and which one's right for you. I'll tell you during the session what I think is right for you based on your circumstances, which will mainly be around what you want to use the system for and what your spend is and what the long-term plan for the package is. We talked to you about the systems and controls that are essential. We talked to you about pricing, big one. How do you cost? You know, we're in this kind of dilemma. I want to earn a living. I'm feeling vulnerable. I'm feeling uncertain. I'm a bit underconfident. Somebody comes in the door and isn't it better to be busy, David, with half a fee than no fee? And I'm going to come on to that later on. So I give you advice on pricing, billing systems, charge out rates, profitability, how profitability varies in different types of work, and people don't really understand that fully. And I also talk to you about how do you know you're on track. Okay, so where should you be at the end of year 1? Where should you be at the end of year 2? Where should you be at the end of year 3? And where should you be at the end of year 4? So how do you know that you're actually establishing a viable business? What are the financial measures that will tell you whether this is actually going well or not? Okay. This is all in this 150 session. Isn't it fantastic value? Talk to you about financing. So every law firm needs some money in it, usually partly from the owners, that's you, and partly from the bank. And every bank is pretty much happy to lend to a law firm if the business plan is right, and as the guy before me said, the presentation is right. So we talk to you about big common misconception is you get taxed on the money you take out, not on your profits. You get taxed on your profits, whether you take it out or not. So people don't follow that. We talk to you about making sure that you're going to get paid for the work that you do. New practices, and particularly female gender practices. I'm sorry for saying that, but they're particularly vulnerable to the client that bounces around and has had 6 advisors in the last 6 years. So startups are because the work that's in play is coming from people that are of their nature probably inclined to change solicitor. I often meet practices, both male and female. They're 6 months down the road and they say, look, I've had a really bad experience with bad debts. And then I go through what their systems have been. And if you think about it, the dissatisfied client, if they've had 5 or 6 solicitors before that they're dissatisfied with, well, the problem is not the 5 or 6 solicitors, to be honest with you. There was definitely 3 or 4 of those that were decent, gave them a good service. The problem is the client. So new practices are magnets for dissatisfied clients. And dissatisfied clients, like we all have nuisance clients. I have plenty of nuisance clients. And my only clients are solicitors, but I have plenty of nuisance clients. But it's a question of filtering well at the start. One of the most successful practices I've seen in Ireland in the last 2 years, the core ingredient I say that guy has is the ability to filter work and decide what he should be doing and what he shouldn't be doing and what he should price it at. And it's a big failure amongst solicitors. We don't filter sufficiently. Okay, so what else do I want to talk to you about? That's ensuring getting paid, ensuring we take the work on. What can you take out of your business? That's a big challenge for a startup. What can you live on? And how do you know what you can take out and what you need to leave in? Talk to you about outlays and whether you're going to pay them for the client or whether you're going to try and get them in every case. This session also, we're still on the Law Society 150 quid practice advisory session, goes through VAT, PAYE, income tax and pension and protection insurance, and a small little session on marketing a law firm. So that's that, 150 euros. And you just contact us. Our contact details are at the end. You don't have to get Law Society permission to do it once you've started. Okay, so I'm on the sales pitch now still. So we're doing seminars around the country. And they're about to kick off in the next 2 weeks. Here's so they're looking at current issues, trends and challenges facing Irish law firms. We're looking at how the market has changed in terms of profitability, pricing and work areas in the last 12 months, how to make profits when fees are tight and costs are rising, how to fund, succession planning, trends in buying, selling and merging practices, can we improve work-life balance and still maintain profitability, so that kind of clash, and managing profitability, where to spend and where to save. The first Dublin one's actually booked out, so if you're in Dublin and you're interested, you'll have to go to the second one. we're in Cork, Limerick, Galway, Carrick-on-Shannon and Kilkenny. It's €125. If anybody here wants to do it and they're paying for it themselves, just send us a cheque for €80. Sorry, and put new practice on it, and that's fine. We'll take your booking. If you're doing it through your employer and that's awkward, we'll gladly accept €125 that the fee normally is. Okay, but that actually will give. There's a PI speaker at that as well. There's somebody on the whole area of cyber. On the PI, there are brokers around that are tied brokers. Okay, so a tied broker is they only have one insurer. There are in fact 2 brokers that can give you access to 7 of the 9 or 6 of the 8 insurers. So you don't have to go to. You probably may have picked up the impression that you've got to go to 9 places to do the PI market. A tied broker is going to say that to you, but there are brokers that can bring you round the whole market except for 2. Okay, and it's probably not fair if I say who they are, but you can talk to me afterwards or pop me an email or give me a ring. Okay, and we've no vested interest in that, but you can do most of the market. The advice is right that you don't send. The insurers think you don't know what you're at if they see multiple proposal forms coming in for the same firm. So if the advice that don't allow 9 brokers send your proposal form to the same insurer is absolutely correct. But there is a lazy way of doing this, where you can cover all of the insurers except either 1 or 2, depending on who participates, and that's not certain yet, through one or 2 brokers. Okay. So delighted to see you at those seminars. There's good CPD credits for it as well. Tips for startups. You're going to need 20 to 40,000 if you're starting up and not buying. Okay. The guy I've just advised on buying, he needs 80. He needs 40 to give to the vendor, and he needs 40 to finance his own practice. Okay, he has the 40 to give to the vendor, and we have done sensible business projections. Talked to the Bank of Ireland. Could be AIB. They're equally happy to bank it, and Ulster indeed. And banks will back startups. There's a fear amongst people starting up of taking on borrowing. Okay, there's this. I don't want to owe anybody. I always want to be cash positive. That's not that logical and not that practical. Okay, and for example, there's absolutely nothing wrong if you decide that you have to finance a number of medical reports because the client genuinely can't finance it. Okay, if you won't finance, say it's a good case, liability isn't an issue, and I'm saying to you, this is the most profitable private client work that's out there at the moment. So your dilemma is, I turn it away or I finance it. The client genuinely can't finance it. It's absolutely fine if you finance that and you have an overdraft backing it, because on the one hand you have you're owed and you owe. You're owed by the client and the insurer, and you owe the bank. So there's certainly nothing wrong with having overdraft up to your outlay, your limit out with clients. Where law firms, that you've all been in other firms, maybe some of them have over borrowed or got themselves in trouble in property transactions. Where law firms have got themselves in trouble in the past is that they've borrowed for lifestyle or living expenses when the practice hasn't been generating it in profit. So I'm saying there's nothing wrong with borrowing for either outlays or for fixtures and fittings or IT systems or whatever. There is something wrong in borrowing. You've got it wrong if you're borrowing to fund lifestyle, even if that's modest. Okay, so you're going to need 20 to 40 grand. That's not necessarily you personally, because I'm also saying to you that the bank will probably chip in 50% of that. Okay, so if you need 20, which would be a pretty low cost startup, if you have a decent business plan, you'll be able to borrow 10 and you need to have 10. Okay? Be competitive on price, but, okay, so you need to eke out a market share, but in the long term, you need to bring your pricing up to the rest of the market, or close to it. And particularly if you have a repeat client, if you start that client off in very low pricing, you will never get them up. You've spoilt them from day one. They have an expectation with you, and it's very hard on the repeat client to build that into a sensible pricing. So it is a dilemma for everybody. And startups are generally, you're leaner. You don't have the overheads of the people you're trying to compete against. But don't go mad on it. And if it's a regular feed of work, and a repeat client, or an arrangement with a mortgage broker and estate agent, just think, will I still be happy to take this pricing in a year's time or 2 years' time? Because I think it'll be hard to work those prices back up. So don't be too silly on it in terms of price. It's incredibly good time to buy a retiring practitioner out. I'm sure Keith, I wasn't here for Keith's session, but I'm sure he said that to you earlier. Yeah, it's an incredibly good time. Imagine buying the guy I've just bought for, he's buying a lifetime business effectively for 20 grand, okay? He's paying 20 grand in goodwill, and he's paying 20 grand that's actually sitting there in work done on the files, and he's sharing 7 litigation fees. That's for nothing. You're buying that practice is actually 78 years old. It has 400 wills in it. I mean, to be honest, like if 4 decent probates come through, it's paid for that practice. So it's an incredibly cheap time. Now, sometimes the vendors, don't want to sign up to reality in terms of what practices are going for. But I can help you on that, because once they hear that I'm involved in it, they say, well, like, this guy knows the market. I'm not going to pull the wool here, because there are benchmarks. And I say consistent things at seminars that are published, that I can say to them, look, I said this at a seminar where I wasn't, coming along on behalf of a particular client. There's my reference material. So, okay. So really good time to buy. It mightn't suit you at the moment, but it might do, maybe in 12 or 15 months. And you don't, maybe just start yourselves and then have a look at it. Target multiple referral points as a priority. What's that about? As well as getting, if you're starting a private client firm, as well as getting 1 client, 2 client, number 3, number 4, you've got sources of work that can give you multiple clients. Mortgage brokers, estate agents. If you're in crime, Garda stations. If you're in family law, other family lawyers, and other solicitors where they've got a conflict, or it's a father child transfer, and you've got to be a little bit friendlier, more open with those people, and they're give to get relationships as well. And they will understand that a startup doesn't necessarily have to give back. But over time, those instructions will wane if your receipt of those instructions. So, I've a firm started relatively recently in County Tipperary, and that person got 25 residential conveyances from his local estate agent over the first 18 months of his existence. 25, fantastic. So instead of getting 25 private clients in, this guy, now he's tried to get the private clients in as well, but the point is, if you can establish rapport with somebody that has a stream of work, that's fantastic. So treat them with kid gloves, but ultimately they're going to have to be a mutual referral thing, otherwise people get fed up and that all collapses. Start with good systems. So what's my advice on account systems? I'd probably give it 3 to 6 months of either going with the system or keeping, it's okay, Excel spreadsheets, etc., which is probably what a lot of you will start on. That's okay for a 3 to 6 month period. Once you get any kind of volume, you need to be looking at a practice management system. They have the controls built in. They'll beep at you if you do something wrong that you can correct quite quickly. So I don't think you should necessarily dive into buying straight away, but if you're very used to a system that you thought worked very well in your old practice, that may well be the right thing to do. Take advice. It's not expensive. Like, honestly, as I said to you, we take a view in startups that you're going to be a lifetime client of ours, and we're not expensive. And taking advice needs to be from, I suppose, not people with a particularly, I just charge you for the time. I know my way around all of the providers in all of the areas. And finally, like it's all about the service. We get what we deserve as professionals. So I'm in a client service business. You're heading potentially into it, or you are already in a client service business. And we, whether it works or fails is basically, if we're fair to people, we're fair to them on price. We do things maybe when people are a bit distressed that, we do a little bit under the radar and free of charge. We're not smart or opportunistic in our pricing. All of those things come back and actually you get rewarded. I get work from people, that I've worked on the opposite side from where been on the other side of a cranky partnership breakup. And, that's nearly the ultimate compliment. So, it's all about the service. It's all about getting back to people. And if you are starting, some of the service levels in the firms that you're competing against aren't stellar. So there's a very good opportunity. So I think it's a really good time to set up. There's good living. You can expect generally in the first year to make no money, to recover your costs. You can expect in the second year to make half a salary. You can expect in the third year, this is if it's going well, to make a salary back, and you can expect in the fourth year to make a salary plus a profit, which is the first time maybe in year 4. That's for a complete startup, okay, that you're above what you used to earn as an employee. If you buy a practice, you'll probably take 2 of those years out potentially, but you've got to sink a bit of money in at the start.
Hi, how are we all? It's been a long day, morning. My name's Sabina Horgan and I'm from Expediate. I'm sure some of you have dealt with me before or heard of Expediate. We've been offering case management software to the legal industry for over 30 years. I myself, in the capacity that I've worked in Expediate, have always done either the sales or the training side of things. So today I'm actually not coming here to talk about Expediate case management. I'm here to talk to you guys about the future of law and how technology can help you as lawyers setting up on your own. And the future for us from Expediate is a product called Thread. Now, I'm going to talk to you about case management in general, but I just kind of wanted to let you know that, software and technology is the best tool that you guys can invest in going forward when it comes to your law firm. It's the foundations of the first letter that's sent out to the client, to how you manage your statute dates, to how bills go out, to how phone calls are received, and how information is tracked. So I really want to kind of help you guys and guide you guys, and I'm here around for the rest of the day should you have any questions. Just a couple of tips that we've learned. Did you know that going digital can reduce a law firm's operating costs by 66%? So for those of you who are in practice at the moment and think about the operating costs and tools that aren't being utilised, it's 66% that you guys will be able to save from day one of opening up your doors, investing in the right system. Also, if we think of the world today as billable hours, and every minute is billable, the idea of being able to capture time and information as you go along is very, very important to you guys. So again, that's something that the right case management should be able to give you. There's a little tip that we want to talk to you today about, and that's Office 365 E3 plan. Now, I was at a seminar in Tralee 2 weeks ago, and Neil Butler, who's the head of technology, has just invested in this, and he said this is the way forward. What an E3 platform is Microsoft's platform that is, I think it's about €17 per user, okay, so per email address. And what it gives you as lawyers, it gives you the platform of e-discovery, ISO 27001. It gives you manual retention policies, data loss protection policies, online backup up to 1 terabyte. It gives you SharePoint, Outlook, basically anything that you can imagine that you would look like, the tools that years ago you would have had to invest in a massive big server to get. So an Office E3 plan would be the foundations that I would recommend for any firm going forward, whether you're starting up or in general practice. And again, that's been recommended by the technology committee. So you're just starting up. Do I really need a case management? Now, I think David was completely right when he said, when we're selling software, we are salespeople at the end of the day. And I will always, whenever I'm doing a demonstration, say to people, at the heart of it, I'm here, I've been 12 years presenting case management to people, and it is the foundations of your firm. So if you think about building a house, you get the foundations right. So when you start thinking about opening up a firm, you need to look at the case management side. So the same should apply to a case management. So what is the brand that you're giving out? What is the client experience? How does the fee note look at the end? And what is that client experience is so important. I go into client sites at the moment, and sometimes they don't get the information sheet at the start. So I always say to them, go back to the days of the dentist. When a client comes in, give them a lovely piece of paper that they fill out all the information. That's the time that you have the information to put into the system. And they're like, God, I never thought about that. And it's the simple things that are the foundations to how your file will grow and be established and processed throughout the time. So do you need a case management system? David's right. He said maybe you don't for the first 3 to 6 months. But what I would say to you with the likes of what we're bringing now with Thread, it's €35 per month for a case management system such as Thread. €35. That's one unit of time in some cases, depending on what hourly rate you're charging. So to get the foundations right, it really is a no-brainer in time. That's your time is precious, so it's very important to make sure that you are making the right choice. So how do you decide what the right software is for you? Well, I always say whenever I sit down and meet people is you're not just buying software, you're building a relationship with your practice manager or any suppliers that come to you. You have to work with them, you have to get on with them, you have to trust them. And I think that's one thing that any of our clients would say in Expediate, that we're here to build a relationship with you, to grow with you, and to ensure that you're not up in the middle of the night saying, did my backup run? Is the billable hours that are in my case management? We will guide you in the right direction. I'd also say shop around. Very, very, very important, because obviously you're looking at a relationship, and it is the foundations of your firm. It's the baseline product. But what I'd also say to you is think about the processes. So as I said to you earlier on about day one, when somebody comes into your firm, what is the experience you want that to be? How do you want a conveyancing file to be run in an automated ideal world? Because the likes of the tools that are out there, and Terry made a really good point about a diary system. Now the likes of the systems is you can open up a conveyancing file and it'll then preempt every single action thereafter without you having to type in anything. So future lawyers, which you all are here because you're taking the leap of faith and looking at going out on your own, technology is a really, really great tool. We've two ladies who signed up with us 2 weeks ago, and they decided to invest in software as opposed to getting administration staff, because they don't need administration staff when they've the right tools in place. So do think about that. Templates. I think it was Simon who mentioned earlier on about investing in your templates and your brand and making sure that you had the right information. That's another area that I really think for you guys about whether do you actually get your letterheaded printed off, or are you actually going to generate it from your case management? The amount of firms that have invested in Expediate and they say, okay, well, I can send that through email, but I'm after spending X amount on my letterhead here that I want to use, when they actually could have just sent it all digitally. So little things like that, your supplier should be able to guide you in the right processes. So do, maybe before you set up, figure out what system you're going to use. You don't have to buy it today, you don't have to buy it tomorrow, but it's just to ensure that the layers that you are building kind of complement the client experience that you want. So setting up your systems, as I said to you, if I was you, I'd process re-engineer. I think about the process from the ground up. What reports do I want from my conveyancing files? What reports do I want? And then think about the actual steps that you need to take in them. Another thing I do, and it goes back to what Terry does, is when you're installing accounts or case management, replicate the PI types of the areas of law. because the amount of firms that have generated their own areas of law, and then when it comes to PI time, they've to export all the data and then start manipulating the different areas of law. So the best thing when you're setting up from the start, complement what's on the PI forms from a area work type point of view, and that in turn come December will help you guys with the PI form, very much so. Okay. So as I said there, oh yeah, and then third party. Another thing to kind of think about is when you set up, it is quite overwhelming, and there's a lot, like David Rowe, what he offers to you guys as startups is an absolutely fantastic tool, and he'd be able to help with the process engineering of the different work types. But as I said, technology is here to stay. We're in a world of smart contracts, AI, blockchain. You know, if you look at your phone now, it's telling you here are all the pictures of the people that are in your phone. So go with the technology, use it to your advantage. And another thing is make sure, no matter what system you go with, you review the package every 6 months. So make sure whatever new tools have come out that you know how to use them, because it's very easy to keep on doing what you always did and not challenge yourselves. But if you spend a half an hour ringing the supplier saying, what are the new features that maybe I am focusing on, that would be a huge advantage to you. So as I said to you, Thread is new to the market. I'm more than happy to talk to you about it, or if you have any other questions on other suppliers, we're more than happy to help.
Okay. Hi guys. I think firstly I want to say that I think this is a great course that the Law Society have put on. I didn't have this when I set up, and hopefully they'll run it again. I think it's very, very useful, and hopefully you'll get maximum benefit out of it. So I was asked to talk as practitioner that I was just set up. I set up on the 1st of February 2017, and I just want to share some of the experience, the do's and don'ts, and hopefully you'll learn from it. One of the key things is also, I must just say up front, is getting a great relationship with your suppliers. And I use Expediate, and they let me skip the queue. It was very helpful. So timing, I just used these slides really as key for me, and sort of key like thoughts or bullets for you if you haven't set up, or if you've just set up and you're a bit overwhelmed by it. And I hope these are just useful. And the first thing I thought was timing, is because before I set up, I had a lot of people, clients, people with the best intentions going, would you not set up on your own? Would you not set up on your own? And I was like, you mad? Like when I was in Fry's, I was like, I don't have the time to be considering what happens when the photocopier breaks down. I don't there's so much stuff, to consider. And I was like, no way. And a colleague set up on their own. I thought he was lost the run of himself, and he's doing great. But it's not about what other people say. It's about, is the timing right for you? And then when I actually, the best thing I ever did was I listened to myself. I listened to my gut. And when my gut told me, now, go now. And I did it, and I wanted to do it. I couldn't wait. To be set up. And that's the time you know that the time's right. So if there's anything, take that away with you. Because once you actually make the decision yourself, own it. And don't look back. Don't waste time doubting yourself. Yes, it is going to be risky, but just listen to your gut. And if your gut is saying the time is right, go with it. There's no guarantees. It's a business. If the gut is saying not quite ready, wait. There is no race to set up on your own. And if anything, that's key. Listen to yourself and then own the decision. My dad was very supportive all the way through, and I'll never forget, he looked at me and I had a business plan done. Oh, don't talk to him about business plans. But the business plan done, I thought, great, and final, and I said it to him, and he looked at me square in the eyes, and he said, are you sure? Well, I nearly died. I went, what? And then I realised what he was doing. He's like, you're making a decision. You need to be confident in your decision. And I looked back at him and said, I am. He said, well then, let's go. And he passed away in May, but I was just it was so smart of him, and he was not a law. He was a farmer and a horse trainer, but he knew exactly what he was doing. He was making me own the decision, and that is key. So that is the first. That's where you start. You make sure that the time is right, and that you make sure that you're sure about doing it now. And decisions. Then you're like, haha, I'm my own boss. So that's a good thing, and maybe not such a good thing. The first decision after I made a decision, I'm going to do it, was actually, I can't be admitting this, but it's actually the colour. That colour. Because I just looked up and I went, that's the colour I'm going to have. It's bizarre. There's no logic to it. But once you're like, so that's not a key decision. Well, it is, because you want, as Sabina said, you want to be able to send emails. You want to have your brand. And you need to think, well, what are the key decisions to be able to start? So not the decisions to be to get you to being the best firm or the best. What are the decisions you need to make, and prioritize those decisions, which is my next thing. Prioritize. Make sure that, okay, well, if I want to give advice tomorrow, what is the first thing I need? I need an email address. It's like, I need a phone number. I need clients. What are the things? You need a VAT number. You need to have registered. You need to know and have a list and do out the list. You need bank accounts. You need a client account. So have those decisions and have it in a list, and then have a different. Yeah, then I go on to that. Then have two lists. Have a list of what you absolutely require, like the law side approval, your bank accounts, your insurance, your accountant, your software. Those were actually one of the first things I got, was a system. If I hadn't come from Fry's, if I went Fry's and set up my own, I wouldn't have learned half of the stuff that I needed to learn before actually setting up my own. I went to Sherwin O'Riordan and got very involved in the managing of the business and the systems, and knowing how important it is, which I did know from a Fry's, having your accounts billing system as well as having the case management system. It's so key. And Expedite had both systems. I didn't have to go one system. They linked together, which is what I needed in my type of work. And another practitioner who actually works from home, he gave me the advice, and it was very important. Don't scrape on your printer. Your printer, scanner, photocopier, do not scrape on it. When that goes, oh my God, and make sure you have a great relationship with your suppliers, because when you get stressed, you sound very narky on the phone to them. So, and that's because you're getting it down the phone for your clients. So do have that relationship. Don't scrape on the printer, scanner, photocopier. Get a good one, because that is key. Scanning all the documents up, having your head of notepaper on your software, being able to email. Don't scrape on that. Get a really good one wherever you're operating from, and have your system in place. Spending, I once I decision and everything. Thankfully, I had somebody that was pulling me back, because I was like, I want to get the nicest office ever. Here was I getting money from? It wasn't, but it was like, no, Anne, really. So I set up an office in Sandyford that wasn't very client facing, but it worked and made me actually spend on other stuff that I needed to spend on, like the Tony Kerr employment law books. I specialise in employment law. And the same girl actually said, are you mad spending that money? And I was like, no, they're the Bibles of employment law. I need them. I need to sign up with them. And she totally got signing up with Expedite. She totally got the printer. She couldn't get that side of it, but she wasn't a solicitor. But I knew that was the spend I needed to do. So you've got to have two lists. You've got to have the wish list. When you do get fees in, that is like, that's my next treat. That's the next thing I'm going to buy. And then it's like I signed up to IRN. I was like, yes, I can do that now. but I couldn't do that at the beginning. I couldn't afford to do that at the beginning. So you've got a wish list and a necessity list. The necessity list is the key. That's your priority, that's your decisions. And the wish list is then, as fees come in, you can go, well, now I can afford that. That will help. Now I can afford that. Now I can afford that. Decisions is also one of the things is, I'll come back to advisors. One of the other decisions is, do you set up on your own? Do you actually need people? Do you need staff with you? Do you need an office, or can you actually work from your home? And that depends on the type of law you're doing, that depends on the amount of clients you have, and your own personal circumstances. I knew that if I set up in where I live, that I'd never turn off. Now, actually, as it happens, I don't turn off, but at least I go home and I don't. I choose when I work at home. It's not my office. I don't sleep in my office, and that was really important for me. And other people are like, what? And the other thing is, like, I could never. I did start with a trainee and the friend that stopped my spending. She was not sort of type for office manager. She was a great advisor, but I needed those people because I was so busy with everything else, which is a great thing to say, that I was busy. But again, back to priorities and decisions, I would do that again in a heartbeat. And a lot of colleagues said, what's the office manager? I said, they take away the stuff that I don't have the time to do. They deal with the suppliers, they do the setup, they make sure the bills are paid, and and chase fees. Now, I've got to another extent which I absolutely will tell you, don't get into the position I'm in. I actually have clients looking for their fee notes, which is bizarre. And people are like, isn't that great? I'm like, no, because that means I'm not getting paid, because I'm not getting the time to put in the time to put to the fee note. So that's a priority that I need to shift and revisit, and I need to keep looking at my business plan all the time. I've actually decided, I regrouped and looked at my business plan again, and I'm moving premises sort of yesterday and Monday, so the address on my front slate is not my address as of today. So I've managed to develop. And as of Monday, I'm moving into Fitzwilliam Hall, that lovely building with leaves at Leeson Street Bridge. Now, I didn't dream that I would be already here, but it's great and I'm very happy. But it was true learning and true, like, there's ups and downs in your business. You've got to anticipate. You've got to just realise you're going to have downtimes. You're going to have to regroup yourself, and you're just going and get on with it. It's not all going to be plain sailing. Then that's with every business, and but that doesn't mean you turn around and go, I should never have set up my own. As I said at the beginning, once you make that decision, own it and keep going. And as I said, the next one, have advisors around. Ask as many questions as you can before setting up or when you set up, and keep going for coffees with them. But also realize that not all of the advice, you don't have to follow all the advice you get. It's things you'll know yourself, things that work for you and things that don't work for you. And don't be afraid to not follow the advice you're getting. Now, unless the Law Society or the bank. But don't be afraid to say, no, actually, I work differently. You don't have to say it to them, just take the advice, thank them, and then what works for you. And some people keep saying to me, why aren't you going general practice? You should be doing general practice, you should be doing general practice. And I was like, I've always been a specialist. Why now would I go general practice? So it just didn't make sense to me. But in their heads, it made sense to them, and they mean the best. But that doesn't mean you need to take that on. Other thing I'll give you, never compare yourself to a barrister. Like, I nearly cried comparing myself to barristers, because you think, oh, they're self-employed, how do they do it? They don't have a big thing that we have. We have to satisfy the clients. We are the ones that actually are dealing with the clients. They don't. So they're laughing. So don't do that. I did it, and it's heartbreaking. The other thing, obviously, I know it looks fairly thing, but it's sort of common sense now when you're looking at it. But fees might get paid for at minimum 30 days or 60 days. You've got to get the fee note out. That's what you need to get the fee note out. And then different people have different credit ratings. And then also you'll have people that will pay you like in installments, but the bills will come very, very quickly, and they will come first. And if you're getting premises, you've got to have a deposit up front. And, you know, and you've got to look at it. The other thing I didn't do on my wish list and my necessity list, archiving. I didn't sign up on an archiving supplier for quite a while. Well, first, there was room for the boxes. Second, it is an additional expense. And it's like, well, now, do I need that now? No, I don't need it now. So I waited until I actually did need it. So that's why the two lists. Like, yes, it absolutely is a necessity, but I didn't need it at the time. The other thing I did was I actually was very lucky. I got an injunction case within the first few months of setting up. So I was able to sign up with the fees of that for ISO certification. And I was like, am I mad? Why am I doing this? But it was great because new staff that were coming in, it made me think about my processes and what I was doing and how I was doing it. And then it made everybody work on the same processes. As Sabina said, think about what you're doing, think about how you're doing it. And the ISO is all about, I had no idea what it was before. It's all about like setting out and writing what you do and how you do it. And literally setting it out like for a child. But it makes you do this whole risk analysis and then turtle diagrams. And I hated that word at the end of it. And then all like your risks. But it was great because this year I went back to it and I went, okay, do you know what, that was on my head, the office, that's risk, that's weakness in my plan. And I was able to address it, you know, so, and then I hired a solicitor. So that was another thing, because people would think, well, you know, you're small, we'd be able to take it on, what's your resources? And I was able to address that. I hired a solicitor a few months ago. So that's the thing, when you make yourself sit down and do the business plan. Now, the funny thing is, my cousin said to me in November before I set up, and she was saying to me, set up on your own, you should set up on your own. Like, you know, I'll never forget it, we were going to a rugby match. And I looked at her and I said, you work in Accenture. You know what a business. She goes, oh, you do business plan and see the pros and cons. And I looked at her and went, business plan? I'm a solicitor. What are you talking about? I don't work at Accenture. I don't know what a business plan is. So, and I said, I just laughed at her. Went into the match and never thought about it again. And then when my gut said, go for it, I Googled for a business plan. And I talked to friends who had already set up. And they were telling me about the different business plans for an insurance and for the bank. That I could talk to you about that different on the side. But and it was very helpful. And but you know, you get it done, you know it. The business plan is in your head already. And it's just, don't be overwhelmed by doing that. But do remember the fees take time to come in, and do give yourself the time to chase them, and do give yourself the time to put your time in and get the fee notes out. Don't be in a position that I'm in. Employees, I address that. I needed support from the beginning, but people would have said you would have made so much more money if you didn't, maybe, but I don't think I would have got the work done to the level I got it done, and then I wouldn't have got so many referrals. Most of my work actually comes from referrals, which I'm so lucky. But I think that was due down to the timing that I set up as well. Because people said, do you regret not setting up before you did? And I was like, not at all. I wasn't ready before I set up. And I also had a reputation when I set up. Now, I had a reputation for a few years, but I had a reputation, I had a client base, I had learned lessons. And be ready to learn. You will learn all the time when you're going through. Each day you will learn a new lesson, good and bad, and be ready to change and adopt. As Sabina said, don't keep doing the same thing all of the time. Like, take that time out, take that business half an hour, take that time for coffee with somebody else to learn something new. and believe in yourself. And I know, now I didn't pick that slide, just saying that, it was my trainee. But don't doubt yourself. You don't have the time to doubt yourself. You're not going to have the time to doubt yourself. You're not going to then make decisions that you need to make if you're just keep doubting yourself. Believe in yourself. Ask advisors. Ask for assistance. There's lots of people that will be willing to help. I couldn't believe the amount of help I got. I had clients that put me forward for awards. I got them and I was gobsmacked. I also have friends that they didn't refer work to me when I was in smaller firm. Now I understand when they didn't refer work to me when I was in Fry's because of the fees, but they didn't refer work to me when I was a smaller firm. Once I set up my own, oh my God, they couldn't stop referring people to me. It was bizarre. It's like, I think it's a very Irish thing as well. People really want to help, and it's great. And take it with both hands. Take the help. You never get enough help, and it really is. It's great. Like it's really, really good, and the well wishers and everything. And if you're like me, the IT help, like Twitter and everything. I was like, what? And I did an article and I put on the website. And I got a phone call then from. I ended up in Claire Byrne's show. It's a long story, but I got a phone call and they said, we liked your blog. And I was like, oh, what's a blog? I don't do blogs. And I was like, all right, but thankfully I dealt with my inner voice. But thankfully I have friends that are mad into IT, and they were like, this is what you should do on your IT. And also I had a bad experience on my first website. And it really, like, that is one thing, do invest in your website. It was, I then talked about it and gave out about it, and I got somebody referred me to a person, and they were on the same wavelength as me, and it was great. I loved then doing the website, and it does take time, but it is worth doing, and it's worth doing well, because I was really disappointed with my first experience on the website. And now it's just great. Now I still can't change anything on the website. I know he's told me like 3 times at least how to do it, but I just keep bringing them up, saying, can you do it? But just IT is not my thing. And that was one of the things that I learned was a website. But don't wait until you've everything in line before setting up. Have your website going along, which you can practice before your website is set up. Don't delay setting up for your website. You're not going to have everything in place when you start, and don't wait. If you know the time is now, go with it. Get all the essential. Website will come into play, but it doesn't need to be in place for you to start practicing. So I said I would be sort of quick. If you have any questions before Shane comes up. No, well, if you think of anything, or you're not sure about doing something, my mobile number, or go onto my website and get my proper number, is the number to get me at. Oh, yeah, they put it up. So, or email me, and I'll be happy to help you with any queries.
Hi guys, my name is. First of all, I'd like to apologise about my voice. I have had tonsillitis for 7 days, so apologies. So my name is Shane. I am a sales manager at Expediate. We do hardware and software sales and IT security for small to medium businesses all around Ireland. We are probably one of the larger providers in Ireland that deal with small practices. I personally have dealt with, I'd say, in excess of 30 companies this year, starting up on their own, and was one that we did last year as well. The role of IT in your business, and I can speak on behalf because I know it, is huge. It far outweighs books and everything like that, because your client experience is everything. So an example is that we have a client who sells a house. He will do a digital rate, or he'll do a rate where you have Mary from down the road who loves a good chat and comes in. So one is 1,500 quid and the other one is 2.5. Either way, the cost of the file is the exact same, just as time is he's billing for the more manual.
the manual conversations, so that he's actually able to provide a file for €1,500 because of an IT system, whether that be case management, accounts, computers, whatever it is. This is the reason why. GDPR, it'll definitely be creeping into your remit. I can tell you, whether you like it or not, it's a huge topic that's going on. The biggest thing with Solicitors is you are easy targets. You are technophobes. You handle lots of client money. Well, maybe not at the start, but you will. And you don't really care for IT, nor do you have budgets. You are the number one target for cybercrime. The amount of money that I personally know of whether clients or friends of clients of ours who have lost last year, and I know they're supposed to report, but obviously you would not, is phenomenal. So that is the reason why I'm going to focus on IT security, basically. I'll be very quick because I know it's a long day. I'll just move on. Hardware. So PCs, laptops, servers, all that stuff. When you look at it, it's very expensive. When you're starting off on your own, when I come into the guys, your monthly costs and your overheads are huge. You do not need to buy a $2,000 server. Not with technology that's out there. You can buy a cloud case management, a cloud accounts, and you can use your home PC for the moment. It's sufficient enough. Okay? Where I will be looking is, you'll be looking at, is my systems cloud? And what that means is, can I access it on the train if I'm going down to Cork? Can I access it on a mobile? And can I access it if I'm up at 12 o'clock and clients ring me freaking? It happens, unfortunately. So with hardware, I would just be careful of what you're buying. Don't spend too much. People can get sucked into going, Jesus, I want an Apple Mac for $2,500. You're going, Jesus Christ, I wouldn't be spending that. Whereas, like Anne said, your printer and scanner is more beneficial than that. Okay. You've got antivirus and firewalls. These are where I would not scrimp. Okay. With IT security, you can get antivirus as little as £25 a month. Okay, just for the peace of mind. Spam filtering is huge. The number one surface attack for you guys is email. When a client will email you saying, Jane, I'm transferring the money, blah, blah, blah. If you are hacked, somebody will intercept that and they will put in their own bank details. You've heard about it, you've seen it in the papers. You might have seen the crowd in the UK last year who lost 265,000 sterling. And it wasn't solicitors' fault, they got hacked. What we say with people with payments, because it's so prevalent now, is that you do two-factor. If somebody's going to transfer you money, you make them call you as well as email. Do not solely rely on it. What I tell clients now is put it at the end of your email. Do not transfer money unless you have spoken to us. It limits your liability. IT security is the biggest thing for you guys. I repeat it, you guys are technophobes. I hate to say it. It's a very backwards uptake on computers. And that's why they're targeting solicitors, because it's happening so much. Okay, so putting in these small precautions, that doesn't cost you anything. Putting that into your email, saying ring us, do not transfer money without contacting us, not just through email. A firewall, you can get them very cheaply. You'll see I'm kind of talking about costs, and I want to kind of get costs in your head because everyone's number one thing is costs, and a budget is something that you will need. The banks do ask you for draft proposals of case management accounts, IT, because I've had to help a lot of people do it. Firewall blocks probably 80% of your stuff straight away. It gives you encrypted Wi-Fi. If you wanted to offer that to your clients, it will stop ransomware attacks. You've seen that in the paper with the NHS, where they got encrypted files. If that happens it is disastrous now. Not just for brand reputation, but also I know of a client who had to go back to their paper files, had to scrap all digitally because they did not have a backup, nor did they have the precautions to stop it. It's very serious, and I would not scrimp on any of that, especially in your backups. You back up your backups. I have clients ring me going, Jesus, can't be affording backup. I said, you can't afford not to. A ransomware attack will cost you in the region of €5,000 direct costs. And then God knows how much else it's going to cost you in brand reputation. And also GDPR now, you will have to report it to the guards, the Law Society, the Data Commissioner, and then an investigation is launched and it's just not something you want to take the chance. Okay. Passwords. Do not use passwords. Do not use lowercase passwords. You want a mix of passwords. You want uppercase, lowercase, and I know it might sound confusing, but you could have Shane. You could have a capital SH at sign instead of an A, lowercase n, number 3 for E, and an exclamation mark. They're not complicated. It's whatever works in your head. An example I use when I'm on websites, so if you're going to the land reg, I use the first 3 letters of any website. So if it's a land reg, it'll be LAN. I would use that, okay? Same at eBay, I would use EBA, okay? And then I would add something like 2018, and I would add the increment of the quarter. So if it's the Q1 in 2018 that I've implemented this password, I go 2018 1 exclamation mark. So, in theory, your principle is your first 3 characters, or whatever this makes sense to you, and just giving you an example, is you use your first 3 digits, and then everything else is the same. So no matter what website you're on, it will basically, you just add on the little bit after. So if it's Gmail, it's GMA 2018, number 1, exclamation mark. It's only the first 3 characters that change. So if you think of how your passwords are done that way, that will save you a lot of heartache down the road. So it's just something to think, because if you have the same password in every website, I'll be able to hack you straight away. And then I'll be able to get into your banking, and I'd say your same 4-digit code or your 6-digit code for your phone is the exact same as your online banking. It's just, people are easily, they like to keep it in their head and keep that repetitive figure. So just be conscious of it. Staff is your number 1 problem. They're interested in everything. You get an email from an accounts from Irish Water, I owe you 150 quid. Oh geez, they owe me 150 quid. You double click on it, you have a virus in your system. You may not know. So staff training, but more importantly, your policies within your office. What is an acceptable usage policy? Now I know you guys are going to be starting off, you may be 1 person, but I've grown with people over the last few years of 1 person, and now they're about 6 or 7, and because they didn't implement the policies from day 1 when they got the first member of staff, it's free reign, and now they're having to implement it now, and Mary can no longer watch Coronation Street at lunch. So your policy of acceptable usage. So it's like saying if you're in your house, your parents go away and you have a free house or whatever it is, and your daughter has a party in the house, and she turns around, well, you never said I couldn't. It's the same with them. Why couldn't I access Coronation Street or go onto streaming or start buying stuff? If you do not dictate the rules to your staff, they'll be able to do what they want, and there's no repercussions for them if it's not done. So it's something to start. Policies with actual computer systems on, you're going to need a lot of policies setting up for GDPR. Unofficially, it's a lot of bump, that's just pages, but what you want to do is you want to have a handbook on your systems that is written down, and it's there. Put it in the corner and say, this is what I do in the event of X, Y, and Z. This is my operating procedures. Having them gives you peace of mind and will give you leniency if anything does happen. If you do not have them, you will be severely punished for it, especially if your client money is taken, or if you have a virus infection, or if your client data is leaked out, which is worst case scenario. If you do get a breach, for all the litigators who's going to start out, you do not have to prove material loss. So if you're dealing with me, my data gets leaked out, I do not have to prove anything, but I can sue you. So that was actually a solicitor that told me that, who is gearing up the litigation for the next few years. So it's just something to think about. One other thing is 2-factor authentication. You have it in your bank, you have it in Gmail if some people have it. I don't know whether you use it, so I'll just keep the slides kind of going. But 2-factor authentication is you have a password. The amount of email hacks we've had to deal with because someone refuses to change a password or gave a password to Mary, Mary gives it out, then Mary puts it in an email, the email gets hacked, whatever happens. If you have 2-factor authentication, it will stop any attempt on your system straight away. And it is free, it is implemented very easily, and it takes no time. And it eliminates 50% of your email threats. Most emails that you will get that are from legitimate sources. So if I was to email you and it looked legitimate, Shane's emailed me, and you click on the thing, that means my email is hacked. If I had two-factor, they would not be able to log in with a password. So what two-factor is you put in a password and then you get a code on your phone, or something along the lines where it will pop up on your phone saying yes, allow. Where this is very handy is that it will happen if you log in from the office. It's not going to ask you, but if you log in from Spain or Czechoslovakia, it's going to go, hold on, you've never logged in here before, get your code. Now, a hacker who has your password does not have access to your phone, and if they do, fair play to them, they deserve to get you, because that is very sophisticated. They're not going to be able to get two of them. But it is it's a free and easy way to eliminate 50% of your email threats. Second one is, if you do not know what the email is about, do not click on it. You'd be surprised. Very simple piece of advice. We live in a click-happy world. Everyone loves to click, click, click. Oh, Jesus, here's another invoice. And if it's not for you, or if it looks suspicious, do not open it. Any attachments, you can open emails, just do not open attachments, because 9 times out of 10 it's malicious. We are first responders for, I would say, last year was an increase of, I'd say, about 60 attacks of ransomware, and it all stemmed from staff members clicking and opening and installing garbage. It's work. So when people kind of come in and say, we're going to implement this fire, you won't be able to go on to Paddy Power, you won't be able to Coronation Street, RTE, Gmail, all this, any of this stuff, and they're going, oh no, Mary's not going to like that, or Una, who goes on to ASOS at lunchtime, can we open it up for lunch? I said, you might as well leave it open the whole time, but what's the point of leaving it open for an hour? Because it's the exact same if you leave it open. So it is going to be your business, the way you treat it. Who's going to pay for the damage that happens? It's going to be you guys, not the staff member. And if you don't have the policies to back it up, you will not be able to discipline that person. So that's why they're kind of they're very important in that. And these are done non-technically. So you guys don't need to worry about it. You just say, I want a firewall, I want to block this, this, this. I want a different Wi-Fi for the guests so that nobody's on. And basically, when you get an audit, or if you try and get cyber insurance, you're going to tick boxes. And like, was it Terry? Terry, what Terry said about the PI insurance, the reason why I was asking him those questions is because I feel that industry is a bit slow in taking up change on cybersecurity and IT systems, because it's probably 60% of your job is done on a computer. It's a guesstimate, but you are heavily involved in computers. Most of your clients' money is handled in computers, the client's information is on computers, everything is on computers. Whereas old school paper is going out the window, really. So that's why do not scrimp on IT systems, but don't overpay either. We kind of, I like to deal with the startups because everyone's going, they're nervous and they're kind of going, oh, Jesus, it's a lot of money, and you're kind of going, yeah, but look, you can do this now. You need this because if you get a virus attack, you don't want to damage your brand straight away. You do not want the Law Society on your back. You do not need an audit. So there's certain things that you will need at the start that is a bare minimum. So buying a super duper laptop is not really it. Putting in two-factor authentication, having online backup, spam filtering, yes. Okay. Office management. We are a Microsoft Gold partner in Expediate. We've invested heavily with them, and we've developed our new solution, as Sabina showed you, Thread. I actually use G Suite personally, Google Suite. I like it. It's simple, it's grand. In a business environment, Office 365 is your only really main choice, because of compatibility to other solicitors using Microsoft Word, Excel, PowerPoint, whatever else you're going to use. But the main reason why we chose Microsoft is they have a data center in Sandyford. Law Society dictates that you must have your data in Ireland, and I think not leave the EU, which that adheres to. It is GDPR compliant. It has certain certifications that tick boxes for us as IT vendors, and also for you guys as users. It starts at about £4 a month for an email license, and that's a domain name. It has spam filtering, it has storage. It is very, very good. The next plan is the Small Business Premium that will include subscription-based Office, which also includes online storage. Okay, again, there's security protocols in here that if somebody tries to access that documents, two-factor authentication eliminates hacking. So with Microsoft, it gives us peace of mind, gives you peace of mind. It gives you GDPR compliance by default. It gives you its ISO 27. There's a load of bump that you can use. All the insurance companies ask us for audits, and we're able to tick all the boxes. So I choose a vendor that you are going to be most comfortable with. In my opinion, Office 365 Microsoft's offerings are reasonable, but they're also business use, and you've used the Office packages before, and they're very cheap. So one that includes Office on up to 5 machines is about 10 quid a month. Everything can be subscription based so that you're not paying a huge amount of money up front. What's next? Spam filtering, again, when you get an email, you're going to get the old King of Nigeria, send me a few bob here, will you? Hoping for the best. They're no longer the case. These guys are so sophisticated. They are companies, there's employee of the month, and they're getting paid bonuses to get you guys. They're going to access your email. If they're in your email, they're going to access it for about 6 months before they pull the trigger. And that's the norm, is about 6 months. That they're going to come in and they're going to monitor their emails. They're going to say, well, he talks to Shane and he goes, how are you, Shane? Instead of hi, Shane, or dear Shane. How are you, Shane? John here. How are you getting on? How's tricks? How's the missus? Whatever. This type of language. And then what they're going to do is they're going to send your clients a dodgy bank account. And this is why the two-factor when making money transfers is vital, because it limits your liability. If that happens, you have no recourse, and I don't know whether you're insured for it. I'm not sure. But having spam filtering, so when you get these emails and you have these precautions in, this is, I think it's about 3 quid a month. I think, like, these are not expensive solutions, but to have them. Basically what happens is someone sends you an email, it gets washed in Office 365, then it goes to another vendor, gets washed again. It's like washing your clothes 3 times before you put them on. That's basically it. That you're having the cleanest clothes on and the cleanest mail, so you're limiting everything that can happen. So if this does happen, or when this happens, because it's only a matter of time, something will happen to everyone in the room. It's unavoidable. But basically, you're going to the opposition, the insurance company, saying, well, we have a spam filter, we have an online backup, we have a firewall, we have policies, procedures, we have cyber security. We've done everything in our attempt to be compliant with GDPR, to put in IT security infrastructure, and that is what, in the eyes of the GDPR, is, have you made the most reasonable attempt at compliance? And that is up to you guys to do. It can be interpreted different ways, but having these precautions listed out, that's basically what you guys need to do. Sabina talked about Thread. What I like about Thread is it integrates with Office 365, therefore giving default compliance for GDPR. You can access it anywhere on a train. If you go down to Cork, we have a client who travels up to down from Dublin to Cork, does not drive, takes the train so he can work remotely because the system is remote. So when you're looking at case management and IT systems, make sure it's future proof, that you're not pumping money into something that isn't scalable. Sorry, I know I'm kind of going a bit over time. Online backup. We provide Keep It Safe for Keep It Safe partners and a new company, DataString, which is online backup. You cannot use your non-compliant ones. So these guys are GDPR compliant. They have ISO certification. But the biggest thing is you cannot use someone that's outside the EU. That is illegal. Your data cannot leave. So it has to be an EU provider, and we choose Irish ones because it gives people peace of mind. These are all the questions that I've been asked before, so stop me if I'm talking garbage. Thread, again, it is the next generation of case management. I'm not hard selling anything or anything like that, but it is going to be a fully scalable product for you from the very start of your firm all the way up to hopefully 20 or 30 users in 2 years, isn't it? So we'll see, but that's where we're at. There is other providers out there. I would definitely encourage you guys to look at them so you can get a very good understanding of what is out there and what they offer. But this is our product that we've gotten huge kudos with Microsoft, that was developed with Microsoft. But you have compliance by default, which is huge for us. Again, policies and procedures. I can't stress this enough. You can download them on the internet. Acceptable usage policy, a disclaimer on your emails. You can get all of these things online, and you can put them in 2 minutes, and it just limits liability. Policies and procedures of how you delete documents and all that stuff it's your own, but you know, we've been asked by a lot of people, if you put them in now, you do not have to go through the heartache of when you get more staff, because it's inevitable you get more staff, that you do not need to put in these procedures. I know David said wait 3 to 6 months to get a case management. It is very hard to implement something when you're set in your ways for 3 to 6 months, and that is a problem. We have people who do case management or they'll do accounts, but you want to start as you mean to go on. You do not want to have to go in and then go, well, we're doing this in Excel, now we're using a whole different source of the system, because people are reluctant to change. So if you do it from the start, and you do it right at the start, and you have the policies and procedures to reflect that, you're winning, basically. The last thing really is what we kind of touched with Terry, is cyber insurance. And a lot of people say it's a waste. I don't know whether I need it. Same with firewalls. Oh Jesus, I don't know, I'll wing it, it's not going to happen to me. Same with antivirus and everything like that. I just want to say, most people in a house will have an alarm system. They'll have a lock on their front door, they'll have house insurance, they'll have double locks in the windows. So if you think of your as your business as a house, if you don't have these procedures, it's only a matter of time before something happens to the house. If you leave the front door open, you're leaving yourself wide open. And unfortunately, where we are these days with cybersecurity, it's no joke. I've seen people devastated, and they've rang me on the phone crying. They weren't clients of ours, but I was asked to help, and they've been crying because they've lost their businesses, basically. The amount of money they've lost. Another dentist, someone I knew as well, they had to stop trading. It's very serious. These guys are very sophisticated. They're smarter than you guys and me. I've seen a Netflix email coming around, and I nearly clicked on it. I'm going, Jesus, that is convincing. So it's no longer a spotty teenager in a bedroom hoping for the best. These guys are specifically targeting you.
Thanks. Okay. So it's been a long morning, so I'm going to get through. I said to Shane, I think yesterday, I would get through this in about 5 minutes. So hopefully you'll be able to go home. Basically, I work for an accounting firm. I'm the manager of the legal department. We've got about 20 clients, and we look after basically the accounts and tax and reporting to the Law Society. So you're going to set up as a sole practitioner or in a partnership, or maybe join an existing firm and maybe work your way up. As David said earlier, there's a lot of firms out there now that are actually looking to possibly get a solicitor who wants to maybe take over. There's a lot of, say, kind of older practitioners who got caught in the crash, who had to work on longer than they intended, and they're now trying to get out. So that's kind of a possibility. But if you're setting up as a sole practitioner or in a partnership, the first thing you need to do is, well, one of the first things you'll need to do is register for income tax, because you're going to be self-employed. It's simple enough. You register online, but it means then you can file your income tax, and unfortunately you're going to have to pay your income tax. So just the income tax return has to be filed by the 31st of October each year. 5% penalty for late filing for 2 months, and then 10% after that. The income that's taxable is the profits of a 12-month period in the previous or ending in the tax year. So, for example, most people would be, if you're employed at the moment, you're just taxed on your PY income to the 31st of December. So, if you set up your practice, you would, if you have a 31st of December year end, you're going to be taxed on that. But some people have different year ends, and that's where sometimes they can get a bit confused. So you could have a 30th of April year end, and that would still be taxable in the tax year that it falls into. So it's just something to consider when you're deciding on your tax year. Your tax year end as well for your accounts will obviously then fall in with your accountant's report, which will be due 6 months after your year end. As David said earlier as well, you're paying your tax based on your profits, not your drawings. So that's just, again, something to kind of consider when you're looking at the bottom line. You have to pay your tax by the 31st of October each year, and then you have to pay preliminary tax as well, and that's the one that people sometimes forget about. So your preliminary tax is based on advanced tax payment. So we're in 2018 at the moment. So this October, people are going to be paying their preliminary tax for all of 2018 in October. Now, to some people that seems unfair that I'm paying a lump sum all of a sudden, but when you consider you've had already 10 months of 2018, then it's not necessarily that unfair. You then, if you make a profit at the end of, or a higher profit at the end of 2018, you then have a balance of tax to pay the following October. We would recommend that you save for your income tax. So you put, once obviously you're making a profit, that you consider putting maybe 10 to 20% of your fees into a separate bank account, so that you are saving towards your income tax bill each year. If you get any kind of cream, then you would put maybe 40 to 50% of those, because if you consider your income tax bill at the end of the year, you're going to have, like, if you have 100 grand, you're well into kind of 40, 50% tax rates. You need to leave that money there somewhere to pay your tax bill eventually. Otherwise, you're going to end up having to borrow from the bank or elsewhere, and banks don't like lending you money to pay your income tax. You're also going to need to register for VAT. You're on where your fees exceed 37,500 in a 12-month period, which I think if you're not aiming for that, well then you probably shouldn't be setting up at all. You have a choice of an invoice basis or a cash basis. Invoice based means that you're paying your VAT to the revenue on the basis of the fees that you're actually issuing, whereas cash means that you're paying the VAT to the revenue on the basis of the fees that you're actually receiving. You also need to file in your VAT returns each quarter or monthly or annually. Again, we'd recommend that you just register on a cash receipts basis, so you're only accounting for the VAT as you receive it. Another thing you can do as well is you take the 23% of the fee when it comes in and you put it into that separate account, so that again, when your VAT bill comes up 2 months later, you have the money there ready. If you want to employ anybody, you're going to have to register for PAYE PRSI. Again, you can do that online. You also have to file PAYE returns either monthly, quarterly, annually. There's a new system coming in from the 1st of January called PAYE modernisation, and that means that you're, rather than kind of doing the monthly or quarterly or annually returns, you're actually going to have to send a file to revenue basically straight away. That is something that you should be aware of. We would recommend, just to jump to the second one there, we would recommend a payroll system, for the software system for that. It just makes it a lot easier. As far as your accounting is concerned, I would disagree with David in that I think you should get a legal accounting software straight away. If you leave it too long, you just get into bad habits, and you need to account for all the money that's coming in, whether it's for yourself or for your clients. There's a lot of good systems out there, and there are varying prices. A lot of them will have light versions, so that you can kind of go in at a lower level. Maybe you've only got a couple, sort of 50, 60 clients to start off with, or maybe even less, And as you scale up, you can buy the more expensive systems. You should also, some of them are better at interacting with the case management systems. I know some of the case management systems sell an accounting software with them, and some don't. But the easiest thing to do is to discuss it with. I mean, obviously, you get, people coming in explaining to you how the systems work. Get referrals. Talk to your friends. You may already have used one yourself in an accounting firm. I suppose solicitors are not don't usually tend to be the most kind of numeric kind of, you prefer to do your legal work rather than your accounting. You need to. You've got to record your income and your expenses. Expenses are probably the one thing that we find that solicitors don't record. So, you're out and you pay for postage for a client, and you just say, well, it was just kind of petty cash. You'd be surprised how much it all adds up to at the end of the year. The same with if you're out driving around clients, you're not recording the petrol bills, stuff like that. So you need to record the expenses of the practice and what you're spending on behalf directly of clients. So that the money that you're spending on behalf of the clients is going onto their ledgers, so you can recover it then at the end of the day. And then you also need to be able to obviously record all the client monies that are coming in. It's as important as anything. Legal bookkeepers. There are some. If you're getting a bookkeeper, they need to be somebody who has legal bookkeeping experience. There's like some bookkeepers will say, yeah, I can do that, but we found that in our experience, the only bookkeepers that are the best are the legal ones. They're not necessarily that cheap, but if you're charging yourself out at 50, 100 euro an hour, maybe even more, the bookkeeper will only cost you maybe 25 to 30 euro an hour, and they'll get through the work a lot quicker than you will. If you do want to do the work yourselves, and I have a client who's been in practice now for about 20 years, and he still religiously goes in every Saturday morning to do his own bookkeeping so that he knows exactly where he is. But if you do want to do that, there's still no harm maybe in getting a bookkeeper in who's experienced, who can at least help you set up what files and stuff that you need to get going. When you're financing your practice, obviously, as David said earlier, you've got your overdraft and then your loans. The bank accounts. A lot of the stuff now is being done online, but you'll still probably need checks from time to time. You need to make sure that those checks on your client account are being returned to you by the bank. So the bank need to be aware from the beginning that you are a solicitor's practice. Sometimes they don't link the accounts. You can link the client account and the office account together, or the bank can do that. And it means then that they can charge, say, bank charges on your client account will get charged into your office, because if they get charged on your on your client bank account, then you're kind of overdrawn. You've basically paid an office expense out, so you need to replace it. You also need to make sure that the bank have set up your accounts with the right names on them. So your office bank account should be the office bank account actually named, and your client bank account should be your client bank account named. Again, the kind of financing as well of the clients and the litigation cases, and David touched a bit on that earlier as well. They're very expensive, so you need to consider where you're going to get the money for those to keep going. We've seen in recent times firms, I suppose, if they're not a no fee, then you're looking at trying to get the clients sometimes to ante up some of those. sometimes, if a client believes in the case themselves, then they won't have a problem, kind of giving you something to get started with. You also then obviously need to consider, as you're going along, the costs of running your practice. So you've got all your office expenses, your PI, your practice and search, then the computers and software, rent, staff, and of course your annual accountancy bill, and then your client outlay as you're going along. Drawings, you need to plan a budget. So set either a weekly or monthly salary kind of for yourself once you get going, and try not to pay personal expenses. We find that if you can kind of think of it as, they're separate. This is your business, and you're at home here. So you pay yourself a salary and then you take, your mortgage, your home phone bills, stuff like that, out of that at home, because otherwise you're kind of intermarrying the two, and you can't see them apart. And as I said earlier, if you get additional fees, then you're going to have additional taxes. You need to plan for the future as well. I'm not sure how much this was picked up on earlier, but you need to consider ultimately kind of planning for and have your pension, have your permanent health, your life insurance, and we're talking about you coming into practice now. You'll need to plan eventually for your own exit. How are you going to exit? You don't want to be the sole practitioner in kind of 30, 40 years time who's kind of hoping somebody's going to come along and buy your practice. So as your business develops, kind of look out for maybe younger solicitors who you can bring in or bring up through your practice to take it over. I'm not even going to bother with this stuff. The Solicitors Accounts Regulations, there are a load of stuff there. Basically, I suppose just the regulation there, you must maintain books and documentation and records to show the true financial position of the business, both of your clients' affair monies and your own. So, as I say, that's why we would recommend looking at getting an accounting system straight away. And then I'll let you read. You have the notes. You can read the rest. It's basically on kind of some of the usual reportable breaches that we see in solicitors' practices. Okay, and we will leave it there. I think.